Hello, good morning, good morning, good morning from Ghana. I hope it's afternoon in Kenya, it's afternoon, getting to evening in Pakistan, and afternoon in Nigeria. I hope everyone is doing well. Welcome back to today's session. I hope I'm audible.
Oh, yes. Good morning. Good morning.
Good morning.
Good afternoon.
All right. It's morning here. Good morning once again. And I guess it's afternoon in Nigeria, it's afternoon in Kenya, and it's getting to evening in Pakistan. It's afternoon in Ethiopia as well. So welcome to today's session. We are at day 2. So let's do a few recap. I want to see in the chat your key takeaway from yesterday. So I want to see in the chat. Let's go. I want to see we're about 20 here. So I want to see everyone typing key takeaway from tomorrow. From yesterday, sorry. Key takeaway from yesterday. I want to see in the chat. Oh, okay. Someone is joining us from Beijing. Okay, it's evening there. Okay, great. Right, so I'm looking at the chat. I want to see key takeaway from yesterday. Okay, someone is saying conflict analysis was good. Okay. Okay. Conflict are inevitable. Okay. Okay, let's go. Keep it coming. Are we there? Only two. Okay. There is always another side of the story. Okay. Someone saying, I like the dinner for two animation. Okay. Once conflict. Okay. There is always another side. ADR spectrum session was new for me and was really interesting. Conflict and eight types was what trigger. I like the dinner for two. Conflicts and it appropriate understanding. The session was excellent. A lot was taken home. Okay, right. Excellent. So thank you all for your input. Yes. So are there any questions someone who want to ask? You can raise your hand and I will ask you. Or if there is any contribution someone wants to make, you can raise your hand. Any question, contribution, addition, subtraction? Okay, some advantages of ADR that gives time, cost effective for choice and okay. The lesson learned from the dinner for two video was different than we answered. Okay. Okay, great. All right, so today we are going to do a lot of work, a lot of discussions, a lot of role plays and other things. So embrace yourself. We're all going to work together to ensure that we get the necessary information that we want. If you check your outline, today we're going to look at overview of mediation. Then we're going to also look at the mediation techniques itself, the process from beginning to finish. Then we can launch into some role play as well. Another person is supposed to join us to do communication, presentation of communication. So that's what is going to happen, right? So without wasting much time, yesterday we spoke about the overview of conflicts for you to understand the basis of the work that you're going to do, because you are going to resolve conflicts, and mostly the ones you are going to do in the subset within the conflict situation, which are the disputes within that you're going to resolve them. So it can be as a result of misinformation, relationship issues, social matters. All these things are there for you to understand, so that in the event that you see any dispute or any matter that is brought to you, you don't look at the face value, but you delve deeper into it. For instance, you do analysis to look at the parties, how the issues has enlarged from the beginning up to that stage, so that at the end of the day, we are better informed in assisting the parties to resolve same. And that is what we have set ourselves to do at the African Center for Collaborative Dispute Resolution. We want to make sure that at the end of, by Friday, you demonstrate quality skills that will be useful within your society, within your community, and being able to assess disputing parties. So you are going to be an agent of change, an agent where people will seek refuge, where disputing parties will seek refuge, where disputing parties will come to you for you to assist them. And that is the focus, and that is the aim of this training. And you want to enhance your skills in order to be able to do so. On that note, let's begin what we have today. So we have mediation, overview of mediation, and mediation techniques, opening statement, signing, consent to mediate. So we're going to discuss all these things to make sure that at the end of the day, you understand the processes. Right. So when we are talking about overview of mediation, you have heard mediation before. So who can tell us what they have heard and have known mediation to be? So those who cannot talk, to put in the chat, what have you heard about mediation and what you think mediation is? And how have you seen mediation over the years? Have you had any experiences in mediation? Have you attended any mediation session? You can raise your hand and I'll allow you to talk, or you can put in the chat. Want to share our experiences? Maybe if you are new to mediation too, you can let us know. So let's go. Want to hear from you. Please put in the chat. Those who cannot talk, if you want to talk to, raise your hand. You'll be allowed to talk. Okay, let's go. I'm waiting. Have you heard about mediation before? Have you had any encounter with mediation? Have you attended a mediation session before? If so, please let us know. Okay, somebody is saying that. Yes, Abdullah, please go ahead. Abdullah, your hand is up. Please go ahead. Abdullah, can you hear me?
Hello, am I audible?
Yes, go ahead.
Sir, am I audible?
I was saying is that mediation is a voluntary process where two parties sit in front of each other to resolve their dispute. And in that proceedings, there is a person who is called mediator who mediate their discussion.
Okay, thank you, Abdullah. So someone has also put in the chat. Okay, hi, Gemma Bayu from Ethiopia. Okay, good to have you. Someone said mediation is a voluntary process which a neutral third party helps disputing parties reach a mutually acceptable agreement. Another person, mediation can be said to bring in two or more warring parties to a common agreement. All right. Has any one of us had any experiences or attended mediation session or has performed any task as a mediator before? Abdullah, your hand is up again.
Sorry, sir, it is not again. I'm doing it first time. My voice, there was a voice distortion from my side, I think.
Oh, all right.
So I'm introducing myself for now. He was someone else who you called Abdullah. So actually, sir, I introduced myself yesterday that I'm from Pakistan, Karachi, and I'm a final year law student. So as far as mediation is concerned, I have completed my mediation training, 40-hour training twice, and I'm a certified mediator. So yes, I have experience in mediation.
Okay. All right. Thank you. Let's move on. Okay. So someone said mediation can be said to bring into.
Can I say something?
Yes, Madam Joy, welcome.
Okay, thank you. Good morning, everyone.
Yes. Good.
Well, mediation, I'm a mediator, a certified mediator, and I've had some experiences in mediation. Well, mediation It's one of the alternative dispute resolution method whereby a third-party person called the third-party neutral called the mediator facilitates communication between the parties to assist them to arrive at a amicable resolution of the disputes. And when we did an overview of mediation of ADR yesterday, giving the various doors in ADR, and mediation was one of those doors given. And there are so many things, mediation, just like the motto of this center, African Center for Collaborative Dispute Resolution, is bringing peace to every home in Africa. So basically what mediation is all about is about, bringing peace between disputing parties. Yeah, enabling peace. At the end of the day, you may not even parties may not settle a matter. Yeah, they may not settle a matter, but that does not mean mediation has failed. Mediation is an eye-opener from experience. It's an eye-opener for the parties, You find out that when there's a conflict, parties no more, their communication, there's a communication gap. Once there's a conflict between parties, so that lack of communication, they cannot agree on anything. So you find out that when they come to mediation, then the mediator facilitates communication between them, engages them to enable them communicate, to enable them talk to each other. At the end of the day, they may not arrive at the resolution of that dispute, but they don't live as enemies. In contradistinction to litigation, like litigation, at the end of the day, the parties live as arch enemies. In fact, that case would outlive them, because it's even they pass it to their children. Both parties, their children cannot marry each other. But in mediation, even if they don't settle, but they don't live as enemies. In fact, as they go back, at the end of the day, they will now see reason to settle the matter. They will now, maybe they will call themselves together. The other one will go and meet the one party will go and meet the other party, and they will settle that case. I've had experiences whereby the parties say, particularly in court referred matters, even in working matters, that the parties say they are going to court or they are going back to court. At the end of the day, they will call the center or call me and say, Madam Mediator, that matter, we didn't go back to court, so we have settled it. So mediation is an eye-opener. It makes the party know that it is better for them to settle. It is better for them to give up something, because in mediation, there's what you call shifting of ground. Parties learn to give up something to pave way for settlement, even if they don't settle, because they have engaged in discussion, and that discussion, that communication, which was not there before they came for that mediation, by the time they finish, even if they don't communicate, even if they don't settle, they will have reason. If they see themselves tomorrow, they can wait, they can stand and greet each other, unlike litigation where they cannot agree. In fact, if one party sees one person coming on the right-hand side of the road, he will just pass on the other side. He will not want the other person to see him or her. So that is the beauty of mediation. Like we are told that when you are comparing mediation and litigation, mediation saves a lot of time. There's unlike a case can last in court for 20, 30 years. I remember in my country, okay, sorry, I didn't introduce myself, even though my name is on a status there. Joy Obungoyon Pobre. You see, in the Lagos Multi-Docket, where I'm a member of the panel of neutrals, there was the very first matter that came when that center was established. It was a court-referred matter that has lasted in court for about 15 years. And it was the parties in that case, they were notable nationalities in the country. That matter came for mediation, and that matter was settled within 2 hours. That's the beauty of mediation. So it saves a lot of time. It's cost-effective, like we were told yesterday. So that's the beauty of mediation. And mediation, everything is, like we were reminded yesterday, it's confidential. It's not like open courts, where court is a public place. Any person can walk into a court and hear your matter, particularly in divorce matter, particularly cases that have gone beyond where in that divorce matter, it has gone to trial. And then you can imagine the public hearing about you, just all your dirty linen in courts. You just, in the family, you just bring it to the fore. Everybody hears about. Unlike mediation, nobody in mediation, parties, you cannot, no any party can take part in that mediation except the parties agree. Like the case I gave yesterday, it was a stranger that assisted us to settle that case in mediation. And we got the permission of the center, of the parties, if they would allow that person to come in in that meeting, and they agreed. So it is very confidential, and that's the beauty of mediation. And mediation, the parties is in control. It is the parties that take the decision. The mediator's duty is just to facilitate the parties and help the parties to resolve their disputes. Well, the mediator may give options to the party, but those options cannot fly if the parties do not accept it. So if there's any option that the mediator has given, you still leave it with the parties to agree on it. If they don't agree on it, you can't impose any option on it. Otherwise, you become a judge or an arbitrator who just takes a decision and grants an award. So that's the beauty of mediation. The parties, they own the process. Yeah, the mediator manages it, but the parties, they own it because they are the one that takes the decision. And in all of this, at the end of the day, when a case is being settled, whether it's physical mediation or whether it's online mediation, you see, the parties at the end, they will shake hands. Even in online mediation, when I handle online, I ensure that the parties, when a case is sent, they will, the other person will call the other person and appreciate the other person for having resolved the other. But in physical one, you will see them physically shaking their hands. I remember a case I was handling, and at the end of the day, the applicant, he was so happy about that case. He said, Madam, you don't know, Madam Mediator, you don't know what you have done for us in this case. That one day I was going for this case when the case was in the High Court. And as I was crossing the road, I nearly had an accident. Everything, I was always thinking about that case. So when that matter is resolved, you see, the parties, they are happy. Even you, the mediator, the lawyers, they are happy for having resolved that case. And when you see that you are able to assist parties to settle their matter and they live as friends, as a mediator, you are also happy. Even the lawyers, and also in mediation, the stakeholders, particularly the lawyers, they perform similar roles of the mediator in trying to, most clients, they believe so much in their lawyers. Anything that the lawyer advises the parties to do, most parties, they normally listen to their lawyers. So I've mediated over matters whereby it is the lawyers that are also assisted in resolution of that dispute. Unlike there are some matters that the lawyers are a clock in the mediation process. Some lawyers, with due respect to lawyers who are here, I always tell the lawyers, I mean, before I even start any session, I would tell the parties, yes, I'm a legal practitioner, but as far as this case is concerned, I'm not a lawyer. I have removed my wig and gown and kept somewhere temporarily. And I also enjoin the lawyers to do so, because in mediation, it is not the law you use to determine that particular matter. It is the interest of the parties. Mediation is an interest-based process. So it is the interest of the parties that you look at when you are handling any mediation. What does the party stand to gain at the end of the day? That is what that doesn't mean when you talk about rights of the parties, then you'll be talking about the law, then you go to court, because there the court, the judge will look at whose rights has been breached. So at the end of the day, it is the interest of the parties. Yes, in mediation, you may see that we are all looking for justice. But whatever the party agrees in a particular matter, that is justice for them. Or on the outside of it, you may say, it is not okay, like in its landlord and tenant matter, where in fact there was a landlord and tenant matter I handled, where the landlady or the landlord was an old woman. And this young woman, the tenant, has stayed in that property for over 3 years, was only rent for 3 years, and he did not pay. And the landlord, this lady had retired from service, and it is the process of that rent. She used to take care of herself and buy drugs. And this young lady refused to pay the rent. The landlady just said, no, you see, don't even pay me. I don't use that money you want to pay me, use it to go and rent another property. Because all the woman wanted, the landlady wanted, was possession of her property. That is what she wants. She wants possession, regain possession, so that she can give it to another tenant who will pay her money for her to use and take care of herself. And the woman, and at the end of the day, that is what we now reduce we reduce it into terms of settlement. Has the landlady agreed? But at the end of before we left, I told you, the young lady, please, it is not, yes, the landlord had agreed for you to go away with the rent. But if I were in your shoes, she's an old woman, and it is that rent that she used to take care of. If I were in your shoes, I will go back. Even if we have signed this agreement, I will go back and plead with her. It is for your good that you pay her that money, so that you don't, nemesis will not catch up with you. I just advise her in that way. So in that kind of a case, you may say that there's no somebody living somebody's and you go away with it. It doesn't look at it, that is justice. But for the parties, for the landlord, that is justice for her. That's why we say that mediation is justice by consensus. What the parties have consented. And that's one of the characteristics of mediation. Parties must consent to any decision that they are going to take. And like we were told yesterday, it's not compulsory. I always tell parties, it's not a must, you must settle this matter. No, it's not a must. In fact, that's another thing I learned that yesterday, that it is not your responsibility as a mediator to make sure that the parties settle. If one party, somebody asks a question, you say, what if the other person is not cooperative, does not want settlement? Yes, there's nothing you can do about it. You don't force settlement. You allow the parties, whatever they choose. Whatever the decision they make, if they want to go back to court, as the family matter I was handling last week, at the end, after having about 4 sessions, both parties, they were sticking to their guns. They wanted to, it was a court-referred matter. They want to go back to court. All entreaties for them to settle, fell on deaf ears right from day one. Before then, you tell them what they will meet when they go back to court. As they are going by, they don't know when that case will finish. They may not even get what they want in court, because even if you have a very good case and you go to court, you don't handle that case, where you may even lose in that case. So, well, let me allow others to talk. Thank you, sir.
Thank you so much. I think you have shared a practical knowledge with all of us, and we appreciate that knowledge that you have shared. Is there anyone who wants to talk or add anything? If not, then let's go straight into what we have. Anyone? No? Okay, then let's move on.
I think that's an excellent summary. Nothing useful to add. God bless you, sister.
Thank you.
Okay, so let's move on. So, when it comes to mediation, a lot of scholars have said a lot of things about mediation. A lot of people have spoken about what mediation is and what mediation is not. So we are going to look at some of them and also address ourselves with it, particularly those who are also seeing this for a first time. Then some of us who are also practitioners, we can also use it as a refresher for ourselves. All right. Right. So mediation has been there for a long time, and it has been, if you look at critically, it has been African dispute resolution mechanism as one of them, where when you have issues within the community, even within the community setting, family to family, they have somebody that they respect within the community that will help in resolving such matter. We used to have family heads, elders, counselors, herdsmen, and other tribal chiefs and as mediators that were helping before the contact with the colonial master. So when the colonial people came, as we look, if we look at the overview of the ADL that was taught by Lawyer Linus, we see that when the colonizers came, the idea was when I have my mechanism that we use, and the Africans also have their mechanism. So whose court do we go? It was difficult for them to accept ours since they have colonized us. They impose the court system onto us. And to do that, they trained some of our people also to become lawyers, and we became akin to litigation. They observed that what we were using at our local level was also effective. They took it, sent it away, polished it nicely, and brought it to us as ADL, which is, they call it alternative dispute resolution. That is alternative to their litigation. But scholars have said that that shouldn't have been the case. It should be the appropriate dispute resolution. So whichever, whether appropriate, whether alternative, whether the most important is ADL is an umbrella body, and within the umbrella of ADL, we have mediation, we have arbitration, we have other mechanisms, ombudsman, and we have hybrid processes, plenty of them. But what we are focusing here is on mediation. This training is about mediation. So at the end of this week, you should be able to practice as a mediator. And if you practice already, your skills should have been enhanced to do more for the society. So before the colonial master, for example, mediation was utilized in the resolution of disputes using elders, counselors, herdsmen, and tribal chiefs as mediators within the African continent and other places. Today, mediation is used in a multiplicity of conflict solutions. So now, mediation, at first, it was used at the local level. It didn't gain a lot of traction and recognition. But now, mediation has gained a lot of traction and recognition. And even because of that, mediation has been able to get an international convention, not one, several of them. Because if you look at ICID, the International Center for Investor State Disputes, which is one of the agencies under World Bank, they have a mediation convention where investors and investors and state can send their dispute and use mediation to resolve. ICC has mediation rules. UNCITRAL model laws on mediation is there. Then in 2018, the world also had now the UN approved the Singapore Convention on mediation. So mediation is being used all over in different disciplines or dispute resolutions when it comes to different conflicts. So mediation can be used to resolve a lot of conflict situations. So it is used in resolution of interpersonal, whether one-to-one conflict, in labor disputes, management, commercial matters, ethnic issues when it comes to social matters, community matters, educational issues when there are disturbances on campus or there are disagreement between teachers and other school authorities and the students and other things. Mediation can be used. Then international issues when it comes to cross-border dispute, mediation can also be used. So mediation is being used all over the world in different aspects. So its propriety, its growth and propriety stem from the deep dissatisfaction with litigation alternatives, the lack of involvement of parties in crafting creative solutions to their problems, and shift from focus on right to a focus on interest. So for instance, when it comes to mediation, the focus always has been on interest, but litigation. Someone is saying no audio. Can you hear me, please? Am I audible?
Yes, you are. Yes, you are.
Yeah. So the kindly check your audio because someone can hear me, others can hear me. So thank you. So mediation is getting a lot of traction or getting a lot of popularity in the system because when it comes to the litigation aspects of dispute resolution, the parties do not feel involved in the resolution of the matter, and that is why even the victim offender mediation even came on board. Because one thing is, when there has been a misdemeanor offense and you jail the person, what happens to the person who has been injured, who needs to be restored? What happens to the person? That the person have to go and take another lawyer, go and do another civil matter before they can get their compensation, while the person is also in prison. So these are some of the things that they realize that even mediation can be used in certain criminal matters which are less or misdemeanor. So they started using even mediation in criminal matters because when it comes to criminal matters, it is the state against the offender. So people do not even feel part of it. When it comes to even your civil matter that you send to court, when you go to the court, it is only when it is time for you to talk or give your lawyer will put you in the box and ask you certain questions, because every conversation within the court is between your lawyer and the judge. You don't even feel part of it because sometimes you don't even know what happened in the courtroom. You go to the court, the lawyer talk, the judge talks, you don't even understand what is happening, and you just hear that it has been adjourned to this. And there are certain even instances where they will tell you that go, your case is not even right for hearing. Whilst in mediation is not like that. Even the day that you submit the matter, if the other person is available, you can sit and talk. So based on the dissatisfaction, people felt the need to start using mediation which will focus more on their interest rather than rights. So you can have your rights. We are not saying somebody should disturb you with your right, or somebody should do anything what your right, or play with your rights. No, that's not what you are saying. But the thing is, the interest, if you are able to assess your interest, you will be able to assess your rights. So that is where people were focusing more. So this has taken a global trend, and mediation has been employed in the resolution of disputes in the following areas all over the world: landlord-tenant issue, as Madam Joy was discussing, landlord-tenant issue. But the thing is, even if the person pays the arrears, the person may even wait, maybe the next payment, the person may not pay. What's the guarantee that the person may pay? So the person felt like, okay, now use the money that you have. I don't want to take it from you. Go and hire a new place and give my apartment to me so that I can give it out. These are some of the compromises a mediation can give. That is what we were talking about in conflict, the behaviors. These are the behaviors that you can see. Somebody can compromise on the fee that he has to take. Okay, go. I can now get my property, give it to another person so that I can get the necessary fees that I'm looking for. These are in order to have their peace of mind. I remember I resolved an issue, I think back in 2015, where a landlord and a tenant, the arrears has been there for about 2 years, and they were owing huge amount of money. But the only thing is now the person has not been paid and the thing has piled up. How do they even decide to pay? So the person decided to pay something. The person gave the other person a check, and he went to the lawyer to tell the person that this person has given me a check. The lawyer said, okay, bring the check. And bring the check. The lawyer kept the check for several months. The check was with the lawyer. And so you were owing someone and somebody has given you a check, at least even cash the check, know that the person has defrayed some of the amount. They didn't cash the check, they were still keeping the check. So when they came for the mediation, after discussing with them, the person said that, yes, I know I owe the woman, but I may not be able to pay everything at a go. So I would want the thing to be spread, but that is why I wanted to make an effort. So I gave them a check, and I don't know whether they catch the check or not. So we find out from do you have what is what he's saying? What do you have anything to say about it? I said yes, there is a check with me. So then we schedule another meeting where she has to go and bring the check. Even the check, the duration has even passed. So we sat down within 2 sittings, we were able to resolve the matter where they were able to even spread the accumulated rent for several years for them to be able to pay. They will stay there and they were paying. So these are some of the things, these are compromises people can make. Then we have personal injuries that people can, personal injuries like insurance matters. People can discuss through mediation and have it resolved. Employment contracts, mediation can be used. Student dispute, mediation. Landlord dispute, mediation. Land dispute, mediation can be used. Commercial contract, mediation can be used. Commercial contract, it can happen in different ways where parties can put a prior agreement in the contract to go for mediation in the event of any dispute. Parties can also decide to initiate a mediation process as they move on with. So then matrimonial property. So it is not divorce, as lawyer clarified yesterday, that it is not the divorce. The dissolution of the marriage is granted by only the court, because the once you do marriage under ordinance, it's only the court that can grant the solution. So when it comes to the auxiliary matters such as sharing of property, assets, time, if there are children, how to meet the children and all that, taking care maintenance and those things, all these things can be agreed upon between the parties. Somebody has put in the chat, said, Isaac, you mentioned mediation can be used in certain criminal matters. Can you provide any real life example of criminal matters which involve mediation? As I have said, without number, that I'm talking about misdemeanor offenses when it comes to it happens in Ghana. I'm talking about like assault and maybe battery, non-aggravated battery. So if you maybe there is a fight between two people, somebody got injured and they went to the hospital, and not serious injury, that such matters can be resolved through mediation when the court decide to refer. So the caveat is that not the parties or the offender who will decide where the matter should go. The matter will go to court, all right. It is the court that will look at the nature of the issue and say that go and settle, so that the victim can be restored. So within the settlement, the criminal nature of the matter changes into a civil matter, although it is a criminal matter. But when they finish, the court will adopt, if they are able to settle, adopt the outcome as consent judgment, and the matter will be resolved. That is what happens. So it is not a matter of all criminal matter. So most important thing is understand that when it comes to misdemeanor offenses, mediation can be used based on the program. If such program is within your country, for instance, Ghana, we have it where we have victim offender mediation. It happens in the courts, where the court allows for mediation, and we even have domestic violence and victim support domestic violence acts in Ghana, which supports the use of mediation or ADR in misdemeanor offenses, in domestic offenses. So if you look at section 24 of Ghana, there is an act, section 24 of Act 732. It talks about the use of ADR in such matters. If you look at the Court Act of Ghana, I think section 73 or so talks about the use of 73 or 72. One of them talks about civil matter, one of them talks about criminal matters. So the court can allow certain criminal matters. So it is at the discretion of the court. If the court look at the matter and say that go and try mediation, it is allowed. So that is all. So it is not the mediator who will go to the police station and say that give me this criminal matter. I'm a mediator, so give it to me so for me to go and resolve. No, the mediator does not intermeddle with such things. It is only the court that can refer. So take note of that. Right. Then we have wills and estates. So there are instances where somebody will die. There is a will, but you see the family. There is a will which has specified how the things will be done, but still the family will be having issues which needs to be resolved. So you can talk about these matters when so that everybody will understand why the will must stand and all that. If somebody wants to compromise on maybe what they have gotten, they can do that. So then parenting issue, maintenance, and those things, mediation, civil, commercial, and civil dispute, all civil and commercial disputes, mediation. Then industrial and labor matters, mediation can be used. Somebody has put in the chat section 345 of CRPC in Pakistan, compromise of murder, for example, of criminal mediation. Injury matters and fatal accident act matter can also fall under the ambit of mediation. Okay, so thank you for the information. So those who are in Pakistan, you can look at it and verify. Thank you. So then we have family dispute, including issues arising of separation and divorce when it comes to party access, property sharing, and all that. Then community and neighbor issues. Community issues, mediation can be used to resolve community issue, then ethnic issues and other things. Then public policy and social conflict. The issues arising out of maybe public policy, mediation can be used. Maybe a decision was taken by a local authority where people are not happy with, a mediation can be used, or a resource control. When there is an issue, there is a resource in a community and there is a policy on that, but people are agitating, the mediation can take effect. Then international issues like fights between state to state, interstate conflicts, cross-border dispute, trade issues, mediation can be used. So there are many other fields into which mediation has extended in other countries. So, for example, in academia, in the church, in hospital. So in hospital and healthcare system, now there is health law where they incorporate mediation into the health system, where there are people specially trained in hospitals and healthcare system where they are able to do mediation. For instance, if you have a dispute with your doctor, somebody will not want to take their doctor to a court. They want to sit and have an avenue to discuss the matter. Some of the negligence issue can go for mediation, where the hospital will be able to pay the necessary compensation to the injured party. all these matters are evolving and it keeps coming. And this is where we want you to also develop yourself skills and be able to function through these areas. Then we have consumer dispute. For consumer disputes, yes, you buy a product and there are defects and other things. There are a lot of organizations that offer such consumer disputes. For gender matters, race, ethnic issue, in assessing claim for injuries, in dealing with farm lender debt issues. So farm lender, when you go to some of the local authority, herdsmen can give their cattle to some people to rear, and they have a share. Some when you come to Ghana, with some of the villages, you go for the local places, you go for land, you work on it, and the proceeds are divided into three. You take one, the owner takes one, and one is used to manage the farm. So then they have the one that is divided into two. So all these processes are there that can bring conflict. So this agreement can bring conflict, and you need people to deal with them. In dealing with prison grievances and for many other disparate purposes and complaint by patients against doctors and others. So there are a lot of diverse ways that mediation can be used, and some of them, because it's confidential, they are used without even anyone knowing. So the list shows the versatility of mediation as a dispute solution tool. So mediation is a tool which, if you are able to master, you are able to use it effectively. So it is used in court system, in community centers, in educational settings, and in law enforcement by police. So when you come to Ghana, as I mentioned the law, there is a DOSU department, the DOSU unit in every police station, in most of the police stations, where when there is a domestic matter, this issue between husband and wife, you can take the person there, where the police try to settle such matters. They use some of them who understand mediation, uses mediation to resolve some of the matter. So now, having understood how we use mediation and how mediation has been used in various and diverse ways, the diverse nature of mediation. Now let's look at some definitions of mediation, or what mediation is and what mediation is not. So the United Nations guidance for effective mediation, which I think it was done in 2012, it describes mediation as voluntary process. So as we're talking about, ADI is a voluntary process. And one of the tools under the ADI is mediation, and mediation is voluntary. So you don't coerce anyone to go into mediation. So it's a voluntary process where a third party assists two or more parties with their consent to prevent, manage, or resolve a conflict by helping them to develop mutually acceptable outcome. Now let's take them in parts. So he said that where a third party, so it means that there is an introduction of a third party, If you are doing negotiation, as you look at the ADR spectrum, negotiation means that only the two parties are meeting to discuss without the intervention of any third party. Even if there are different people involved, those different people involved represent the interests of either party. So that is negotiation. So when it comes to mediation, it means that there is an introduction of a third party into the negotiation. So where the third party is neutral, the third party does not side with anyone. It comes to assist two or more. So mediation parties can be two, it can be more. So it can be several people. So it can be multi-party mediation with their consent. So one key thing you have to also understand in mediation is that there is always consent. Consent. So there is always consent. What do we mean by consent? Who can explain to us? What do we mean by consent? Please put in the chat. I want to see you typing. What do we mean by consent? When you say your consent, we are seeking your consent. What do we mean by consent? I'm reading in the chat. Let's go. Consent.
Okay. Can I say something?
Yes, please go ahead.
Yeah, consent in mediation is when both parties they've agreed to go for mediation, both parties must agree. Because if they don't agree to go for that mediation, they may have some challenges. So the parties must consent to engage in mediation. That's why even before mediation starts, you give them the relevant, give parties the relevant mediation forms, like the agreement to mediate. If they don't consent, they can't sign that form. So they are not being coerced. There's no coercion that they are being forced to go into mediation. So they have, and the fact that they have surrendered or they have submitted to mediation, it means they have agreed. Like even courts cannot even, like in Nigeria, courts don't even force parties into mediation. I remember in a case that has lasted in court for over 3 years in the chambers I was in. In the court, the judge just said, Mrs. Mpubre, this matter, in the next 2 weeks, there'll be settlement week in Lagos multi-door court. I want to send you people to the multi-door court to go and settle this matter, because it was a matter that should not even come. You know, there are many matters that should not even go to court. And thank God that day, I was the plaintiff counsel, the defendant counsel was there, all the parties were there in court. And the judge directed the registrar to give the parties, to give us the relevant mediation forms to sign. And we sign all with confidential form, sign agreement to mediate. We sign all those forms. So we might not, nobody was coerced. So the parties have to consent to it. Then at the end of the day, when the mediation session has held, maybe 1 or 2 sessions, and parties have agreed, they must agree to whatever decision. One party can make an offer. The other party must consent to it. If they don't consent to it, it doesn't fly. And such agreement must be equitable, must be justiciable, and must be reasonable that the other party can accept. So if they don't consent to that agreement, to that decision during the mediation, then there's no, it cannot fly. That's why, like I said earlier, that mediation is justice by consensus. So the parties have to consent to it. Thank you.
Okay, thank you. So somebody said permission, someone said consent means giving permission freely and willingly. Somebody said seek approval or agreement of the disputant. Someone said consent can mean written authority to participate in mediation. And then somebody said voluntary agreement on their own permission. Yes, thank you. Or Abdullah, your hand is up. Hello, Abdullah. Abdullah. Abdullah, can you hear me?
Sir, am I audible?
Yes, go ahead.
Yes, sir. So I was saying consent means permission, which is taken through agreement to mediate. And this also relates to voluntariness. So this consent starts from agreement to mediate until the agreement settlement. So in meanwhile, the parties have right to leave the mediation if they think the process is not working for them or they are not feeling comfortable. So they can leave anytime. So I think this is consent from agreement to mediate and before the settlement agreement is signed.
Okay, thank you. Okay, so thank you all. That is good intervention. So one thing you have to know about consent is that consent means that is the first agreement from the parties. So mediation is based on agreements from the parties, so parties own solution. So it means that is the first agreement from them. The parties have agreed the first agreement. So you are getting some agreement now. That is the first thing that they have agreed upon, that, oh, we want to go through the mediation process. The, they are coming to the mediation out of their own volition, and it means that they are going through the mediation with the party autonomy, and also they have also given authority to the mediator or the mediation institution to assist them. The fact that they have given you authority doesn't also mean that you can take decision for them. No, they have given you, the mediator, authority, the go ahead, the green light to assist them to go through the mediation process. So that is what I'll add about consent. So going forward, then he said that either mediation can also be done to consent, to prevent. So it is not only about when issues has happened. That is only when we do mediation. So mediation can also be done when you see that there are tensions, that you can use mediation to deflate the tensions. Parties can initiate the processes and use mediation to deflate tensions, so to prevent. Then when issues has also occur, can manage the conflict situation, and if the need be, can also be used to resolve the conflict by helping them to develop mutually acceptable agreement. So the agreement must be what? Mutual. It must be agreement that is consensual, what parties have agreed to do, not what someone think that the parties must do. So in mediation, you don't come out with recommendations. You don't come out with key points that you think should be done. You come out with an agreement that has been agreed mutually by the parties. So that is what happens in mediation, according to the UN, United Nations Guidance for Effective Mediation. That is one. So let's move on and look at the second definition. So the second definition is by the United Nations Convention on Settlement Agreement resulting from mediation, aka Singapore Convention on Mediation. So definition of the mediation according to the Singapore Convention. So the Singapore Convention, in a very broad manner, defines mediation as a process. So it sees mediation as what? A process, irrespective of the expression used. So when we say irrespective of the expression used, I'll come to that. So think about it. What does it mean? So we can put in the chat. What does it mean when it comes to irrespective of the expression used? Or the basis upon which the process is carried out, whereby parties attempt to reach an amicable settlement of their dispute with the assistance of a third party or persons lacking the authority to impose a solution upon the parties to the dispute. Who can explain this? Who can explain this definition? Hello, yes. Abdullah, go ahead.
Sir, if I simplify this definition, this says that the mediator, the first thing is that the mediator will only facilitate the parties, and the second thing is says irrespective of expression used. It means whatever the procedure you follow, there is no any rigidity. The process is flexible. However you feel comfortable, you can use the process. And the third thing says that the mediator has no authority to make the decision binding on the parties.
Okay, thank you. Any other person? I need another person. Or okay, I want to see everyone typing in the chat. I want to see about 10 comments. Let's go. Oh, I want to see. I can't see anything in the chat too. Let's go. Are you here? Are you with us? Want to see? This is an interactive session. So talk, I talk, we talk, you are talk. Then we are moving on. It shouldn't be me, Abdullah, and Madam Joy. No. All of you are supposed to be talking. We are all learning. Right. Right. So if you are not talking, let's move on. So what we are saying here is that it doesn't matter how the process came about. So irrespective of the expression used. So it doesn't matter also the expression used, whether it was, oh, this was not mediation or that was not mediation. This definition settles that. But the most important aspect of it is that the process at the end of the day, the person assisting the parties to go through whether the process is mediation or non-mediation or whichever process, that person should lack the authority to impose a decision on the parties. So any process that the parties on their own are able to come out with solutions that are mutually agreed, then it means that the parties are doing mediation according to this definition. Yes, great. Now I've seen some charts. Good. And under the Singapore mediation is defined as the process whereby parties reach friendly agreement with the help of a third party mediator who does not have the power to impose a solution. Simplify the phrases, assisted negotiation, a neutral person help talk, but you keep all the decision-making power to the party. So good. Then Brahma also said, not about giving in. This is the common misconception. Choosing mediation is often a sign of pragmatism, strength, and desire for control. It is proactive to resolve a dispute intelligently, often saving significant time, money, and emotional energy. Brahma, you're not talking about the definition here. Thank you, but thank you for that intervention. All right, so whether you do we conduct the process as mediation process, we know or not. By the end of the day, if the parties are the one who took the decision without any decision not handed to them, then it means that mediation has taken place. Then we come to types of mediation. Mediation has types. There are different types of mediation. We have facilitative mediation, where parties are encouraged to negotiate based upon their needs and interests instead of their strict legal rights. So people may come for mediation, and some of them want to insist on their strict legal rights. There are people who come for mediation and do that. They want to insist that, oh, if I go to court, I'll get this. If I do, I get this. If I do, I get this. But you assist them for them to understand that, yes, they can insist on their legal right, but these are the consequences, these are the issues. So you play a facilitative role, which is the mostly common mediation practice, where you ask open-ended questions to assist the parties to assess their needs instead of their strict legal rights. Then you go to settlement mediation, where parties are encouraged to compromise in order to settle the dispute between them. So here, effort ideas toward parties seeing the need to compromise or shift their boundaries, what they want to still focus on, so that the matter can be resolved. If parties stay at that place, the matter cannot be resolved. So if they are able to shift, then the matter can be resolved. Then we have transformative mediation, where parties are encouraged to deal with the underlying causes of their problem with a view to repairing relationship as the basis for settlement. So transformation look at what brought the issue, what has been the underlying issue. So if the underlying issue, if you are able to deal with the underlying issue, then you can resolve the matter. But once we are taking you through all these types of mediation, it can interface, or you can do all of them within one mediation. At a point, you can be doing facilitative. At a point, you can be doing settlement. At a point, you can be doing transformative mediation. But there are certain mediation where you need to go deep behind what has been presented for you to understand, or for the parties themselves to understand each other's perspective before the parties can resolve the matter. Then you have evaluative mediation, where parties are encouraged to reach settlement according to their rights and entitlement within the anticipated range of court remedies. So if this type of mediation, when parties are disagreeing or they are not agreeing on the issues, the mediator can assist them in evaluating their claims or their entitlement and their rights, and to find out or to let them understand, even if they go to court, if they are looking for 20,000 and you go to court and the court will give you the same 20,000, why then do you go to court again? So it is important for you to settle. So if they can, based on this, they can agree and settle. Yes, engineer, please, your hand is up. Go ahead.
Yeah, thank you very much, Professor Blue, for your chance for me to talk. Yeah, in the evaluative mediation, this is why in the case of the Boku and Asantehime Otumfuo, his presentation was discussed and argued by many as an evaluative mediation because he went back to court decisions, etc., and that guided the settlement. The only other argument was that the parties themselves were not involved, or well, they were involved, but it appears they did not agree to the evaluative mediation. I don't know those in Ghana who followed the case are on this platform, what they think. Thank you.
Okay, so engineer, at the end of the day, what do you want them to tease out?
Yeah, the teasing out is that once we now know, or we know that there are types of mediation, and that what was done for the Boku case was effectively that of an evaluative mediation, because people say it was not mediation at all, it was arbitration. But I see that it's actually an evaluative mediation because the parties were called to the meetings, except that people are arguing that the parties did not agree.
Yes, okay, thank you. So the most important thing is that you can do transformative, evaluative, settlement mediation, or whichever mediation that you do. At the end of the day, the end product should be that parties, having gone through the mediation process, have agreed on the following. So if the Otumfuo's presentation has been that both parties have agreed on the following, then nobody will have qualms with it. It doesn't matter whether evaluative or whichever. But once you present it as a recommendation, then it means that the parties have not agreed. It is you, the mediator, who has done an assessment, and you think that this should be the way forward. So what would have happened is that after the mediator had done those assessments, the mediator should have further met with the parties and present these suggestions to the parties, for the parties themselves to assess what the mediator has presented to them, to either accept or reject before it can even come to the public. So that was where the defects happened. And it brought a lot of discussion around it, right? Somebody has also posted in the chat. Okay, or engineer, you want to say something further?
That's right. Okay, thank
you. Okay. Somebody has posted in the chat. He said if third party won't be given any authority over the solution, then why didn't the disputants solve their problems by themselves? Why invite a third party yet limit their influence? What exactly then would there be of the mediator? Of what relevance would the mediator be to the process of the resolution? Yes, that is a good and fantastic question. But at the end of this presentation, you will understand why a mediator is given that role, and The fact that parties are fighting doesn't mean that they don't have solution. That is what I want you to understand from here. That once parties are fighting, it doesn't mean that they don't have solution. They have been clouded by sometimes the anger or issues surrounding the dispute among them, so they are not able to agree on certain things. Sometimes the agreement is right with them, the solution is with them, but they are unable to agree on them based on the challenges that they are having with themselves. So what happens is that the mediator comes in and serves as a tool and a sounding board for the parties, so that each party can understand each of them, each perspective of the issue, and the mediator also help them to expand the resources that they have, so that they can agree on what they want to do without the mediator telling them what to do. So the mediator play a critical role when it comes to mediation, but you are not given the power to decide for the parties. You are not an arbitrator. You are not a judge. It is only a judge or arbitrator who listen to the parties and say that this person is right, this person is wrong. But the mediator does not do that. You help the parties. You assist through communication, through your skills that you learn here. You'll be able to do that. So let's move on. So authority. So yes. So this also leads to your question again. Authority of the mediator. So the mediator's authority resides in his or her personal credibility. So your authority to assess parties reside in your personal credibility, your integrity, and your trustworthiness. Expertise in handling the negotiation process, experience in handling similar issues, ability to bring parties together on the basis of their own interests, past performance or reputation as a resource person, in some cultures, his or her relationship with the parties. So the mediator is not given a blank check to do anything that you want. You, the mediator, must also gain trust of the parties. That becomes your authority. Parties trust you. You are able to shape their resolution for them. So you get to a point where you understand that parties, you'll be able to ask parties open-ended questions who should shape them. And sometimes you also be able to identify certain key solution that is being proposed by one party that the other party is not able to see. So that is why the mediator assists them to see that, okay, this person is saying this person is saying that. Somebody will say something and you pause them and say that, can you repeat what you said? So did you hear the person saying this? What do you think about that? So that is your role as a mediator. That is what you do. You are able to serve as a sounding board where the other party may not hear, you hear. Then you let the party, you draw their attention. That may be a key breakthrough for your resolution of the matter. These are some of the things that we want you to understand. So authority or recognition of the parties of the right, authority or recognition of the right to influence the outcome of the dispute is granted by the parties themselves rather than by external law, contract, or agency. No law impose a certain power on the mediator to do certain things. No. Everything, you the mediator, your appointments, when it comes to your selection, it is a party that will agree for you to serve as their mediator. Selection processes can take different format where the parties can say that AfCCoD appoint a mediator for us to accept, or provide us with a list of qualified mediators for us to choose from. So all these things can also be done so that parties can select the needed mediator that they want. And based on that, the parties will now confirm their authority on the mediator. The parties themselves confirm that this is the mediator that we want. This is the person we want to use. This is the person we feel that we can help us. So your authority and everything comes from the party. Now, we look at the skills of the mediator. So what should be the skills of the mediator? We will not say, or somebody say now, although the mediator has no power to impose decision, but the mediator is the authoritative of the process. I would not want us to use authoritative. Rather, the mediator will serve as a pivot of the process or conveyor belt of the process. He manages the process like the driver, not the authoritative. No. Right. So skills of the mediator. That notwithstanding, there are certain fundamental skills and core skills associated with being a mediator. Among common of the features of the mediation are the following points. So you, the mediator, is supposed to serve as this in the mediation, neutrality of the mediator. So the neutrality and impartiality of the mediator are of fundamental importance to the process. Your neutrality and your impartiality is fundamental to the process. So the mediator should be a person who will serve as a neutral person. For instance, you come and the person start talking, you start to interject, to ask certain questions that the person will feel like, why is the mediator doing that? Or sometimes one person is talking, you are looking at the person, another person start talking, you start looking somewhere. So your actions, your gestures, everything that you do must demonstrate to the parties that you are indeed neutral and you are impartial in the process. Authority of the mediator. So the mediator has no authority to impose a settlement on the party. Let the parties know. These are the skills that you demonstrate. Let them know that you are able to assist them. You are going to assist them to go through the process. However, they are the people who is going to make all the decision, and you are going to assist them to do that. The decision, they are people who have the solution of the process is in their hands, and they have that power to do so. And you know that they know that they have the solution, and you encourage them to bring those issues out for them to be able to be resolved. So don't go in saying that. So some people, I'm coming to resolve the matter. You are not the one to resolve it. The party that will decide to resolve or not to resolve. And most importantly, as I mentioned yesterday, whether parties want to resolve or not to resolve, it is not your problem as a mediator. You make sure that you do all the necessary things. The most important thing that you have to do them. If the parties are not willing to resolve, leave them. It is not something to worry about. So the mediator is only a facilitator of the process whose role is to assist the disputants to settle their differences through a negotiated settlement. Mediator involves some element of facilitation and assistance so that the parties or the disputant can negotiate with one another. Then the mediator should also have a skills of making sure that every issue is consensual. So consensual, so mediation is consensual. So the only binding outcome is the outcome of the mediation is the one which all the parties agree. So the mediator, you don't go and say that this is what I propose for you, so accept it. No, it should be a consensus between the parties, what they have agreed. Then maximization of interest. The objective of the mediated settlement, unlike an adversarial trial, is to maximize the interest of all parties. That is what we call both gain. So you maximize the interest of all parties. All parties' interests are maximized. So what do we mean by maximization of parties' interest? What the parties want, what they must have. You maximize, you let them understand, you ask certain questions to know that what would you want to settle today? What would you want the agreement to look like? What do you want to see? These are certain questions that you ask them for them to come out with what they want to achieve. So then provision of secure environment. Mediator, you must demonstrate skills and also be sensitive enough and provide secure environment. So it is the mediator's responsibility to create conditions. So the person must feel comfortable. They must feel that the mediator will protect them. They must feel that they are in an environment where they can share their sentiments or how the issues has affected them and how they can get solution to that. So it is the mediator's responsibility to create conditions which are conducive to discussion and the exploration of settlement options and possibilities. So this applies not only to the physical arrangement and the ambience, but also to the ground rules regulating the process. So before the mediation starts, what you put in place to let the parties understand that the mediation is free from certain vices. People will not use certain derogatory words. People will not use certain gestures. People will not do certain things. Letting them understand, for them to understand rules that governs the discussion. When one person is talking, the person will be allowed to finish, and the other person can bring. All these things are done in order to create a safe environment that builds trust, that gives confidence to the parties to resolve their issue. So offer of confidentiality, you the mediator. So mediation is, and by its very nature, a private and confidential process. So the mediator must first offer confidentiality to the parties, who may also agree to mutual confidentiality. So you the mediator must let the parties know, you must let the parties know that all the processes that you are going to do, you the mediator will keep it in confidence, and the law also does not allow you to disclose it to any other party, any third party, and you expect them to do same. And the only document that they can disclose is the outcome for the purpose of enforcement processes when one party fails to honor their part of the agreement. So all these things must be discussed with the parties, and you, the mediator, must offer that confidentiality and let them know that you are going to keep all their information private. So mediation by its very nature, it is what nature a private and confidential process. So the mediator must first offer confidentiality to the parties, who may also agree to mutual confidentiality. So it is important for you to do that. So somebody is asking, or said, please, as a mediator, if you can't resolve a conflict, is it advisable to tell the parties to take the case to court? Like the mediator, you are not a legal advisor. So what the mediator can do is that at this point, I can see that mediation will not work well, or mediation is not feasible for the both of you. So I want to suggest that you use another forum, and that's it. So you don't go and say that with this very nature of the dispute, I suggest that go to court, and court will be helpful. It is not your duty to advise any of them to go to court or tell them what to do. If you cannot do what they have asked you to do, you must disclose and they give reason why you are unable to continue with the mediation, and that's it. So you don't go and advise them. So a neutral third party who helps disputing parties to reach a mutually acceptable agreement. Okay, so somebody posted that. Then let's go on. Inability to offer independent advice. So Jonas, this is where your question comes in again. So you are unable to offer independent advice because in mediation, the parties are responsible for their own decision. And mediator is not supposed to offer advice to the parties. Where appropriate, the disputants may take advice from the independent source, but they may not do so from the mediator. Mediator can only ask open-ended questions. Maybe, are you aware of this? Have you seen this? Maybe if it is a law that you want to even point them to, you can find out from them. Are you aware of this law? Have you look at them? Do you understand this? Okay, you can consult your lawyer for more. All these things are very important so that you don't get yourself into trouble. Any question up to this point? Any question? Any question? Okay, if there are no questions, I'm going to take this screen off. I'm going to take this screen off. Then we are going to YouTube again. We are going to YouTube again. So we are going back to YouTube to see if we can get a mediation video. So we are going to watch a video. So type, there is a mediation video I normally use, business mediation demo. So this one. Okay, so I'm going to start this video. I want you to watch for the next 53 minutes before I'll continue with the mediation process. It will help give you an idea, fair idea to go through the process. So I'm going to start. Sit tight. That's why I'm playing it from YouTube for copyright issues. We don't want to have any copyright matter. It is not for us. So we are playing from YouTube for you to watch. All right,
the mediator welcomes both parties to the mediation session and introduces himself. The mediator thanks the parties for choosing to use mediation as a possible solution of their dispute. After a
Please, can you hear the sound?
Yes, sir.
Okay.
Yes, sir.
Yeah,
Right.
yeah, we are hearing.
Okay,
formal
so let's
introduction,
watch.
the mediator explains the principles of mediation, in particular confidentiality, impartiality of the mediator, voluntary basis of mediation, and the rules of a mediation session. Both parties are asked to approve the rules and whether they need any explanation of the principles of mediation. There are no questions. The mediator stresses the fact that all the principles have been described and explained in the written contract that has been signed before the session. The mediator also explains that both parties are the only ones who are responsible and able to find the solution of their mediation. After this introduction, the mediator asks whether there are any questions.
Thank you for agreeing on a place and time to meet and for being present today and very accurate. Thank you both. Now, as you know, my name is Georgi Olenkov. You could freely call me Georgie. I prefer first names. And I do work for CDR Associates as a professional mediator. It would be my honor today to assist you in trying to solve your commercial dispute amicably. Now, just very briefly, prior to beginning with the actual negotiation, I ought to say that today we'll be reasoning out solutions for your commercial dispute so that the present situation within the company you're holding together will be altered in a way that will not affect adversely any third parties, the functioning of the company itself, or the provision of quality services, which you both stated in the pre-mediation discussions and as being of utmost importance for you. So now I ought to say that mediation is an entirely voluntary process. You're here because this is your business decision and your willingness to try to reason out jointly solutions for what you're facing. I do not have the authority, nor will I attempt at any point to make any decisions on your behalf. I'm not here as a judge or an arbitrator. And also, I will try to maintain throughout the whole session my utmost impartiality. So please know that I do not hold any preconceived biases towards any solution to your commercial dispute or towards one of you over the other. So should at any time you feel that my impartiality is compromised, please bring this behavior to my attention and I'll try to alter it. Once more, you're here because this is your mediation. At any point, you may decide to stop negotiations, replace the mediator, which I strongly advise you against, and also pursue other means of settlement, though I strongly encourage you to give a chance to our meeting today. So, the floor will be yours in a minute, but first, just two procedural guidelines. The first one being the following. At some point, you may want some break from the joint session and you may wish to meet with me privately in a separate meeting or the so-called caucus, where we shall discuss matters that, for instance, you feel uncomfortable to bring out in the joint discussion. This is an option for you, so keep it in mind. And also, what my experience tells me is that it's good to start in the very beginning of the session with some uninterrupted equal time for either party to explain their perspective, how they perceive the case at hand, what brought them to mediation. So should this idea for uninterrupted equal time be okay with you?
Absolutely.
I would like to begin in this way. All right, then thank you. I think we can start. And Mr. Sharp, you were the initiator of this session, so maybe you could begin with the elaboration. But prior to that, just tell me who you are, what brings you to mediation today, and give the floor to Mrs. Smith to do the same. Then, if that is okay with Mrs. Smith, you can begin with your elaboration.
Okay, thank you. So, my name is Jan Sharp, and I'm the shareholder of the company No Need to Pay Limited. I have the 50% of the shares, and
I have
my
the other
colleague-
50%.
Yeah,
of
she's
the
the
shares.
that's
My
the
name
problem.
is-
That's the biggest problem.
Well, my name is Julia Smith, shareholder in No Need to Pay.
Yep. Unfortunately.
All right. So please.
So the company, we are working in the field of the tax optimization and tax consulting, and we established the company in 1992. From the beginning, the company was working very well. We earned a lot of money. We have a lot of clients, and the business was increasing very highly and very rapidly, I would say. So both of us were very happy. We earned a lot of money, so we just started to do another businesses. We bought 4 houses, so we work in the real estate area as well. And also, we do the training for the tax professionals. This is the activity of our company right now and from the beginning. According to the fact that the business increased very largely and very rapidly, we divided our activities between us. We are both tax professionals, so we provided our clients we used to provide our clients with our services. And I'm specialized in the client acquisitions, and she is supposed to work in the area of real estate and the training. So that's the basic situation right now. And everything was working perfect. A very long time. We were kind of happy, I would say. We were friends. Everything was perfect. About 1 year ago, something happened. I really don't know what, but something happened. We are not able to cooperate. We are not able to work together. We are not able to communicate. And right now, the situation is that I'm the only one who works for the clients from the beginning till the end. I'm the only one who makes the profit of the company. And I'm the only one who does all the activities of the company. And she doesn't do anything. She's saying, I'm working for the real estate things and the training, but it's not sufficient. Right now, I don't want to be useful idiot anymore. I'm the only one who earns the money, and she's just
Come on,
getting over 50% of the profit. No, that's not
Are
true.
you kidding me?
Do I
That
look like
you're
that?
the only one
Yeah, I'm the
who ever done-
only one who earns the money, the whole money. So I'm the only one who works
And where do
24
you
hours.
think the money
7
comes from? I'm sorry
from
for
the
being
clients. From the
curious,
clients,
but
I get the
which
clients. I work
Which
for the
clients?
clients.
And so
All
when
the clients. We are the taxation. We are the company that works for
we're a
the client.
We are a training company.
Training company.
That's
It's a
professional.
completely different company than I have.
Well, then maybe we have different companies.
Yeah, it seems to be. So let's finish this, settle it down. I will get the money and get rid of this company. I will with you completely.
If
That's
I
okay.
may
This is how
step
unreasonable
in,
it
if
is.
I may step in, I think this was useful. This little
But
confrontation
it's
to
true.
just
It's not only useful. It's
let some steam go off. So now
I don't know.
at such times, I always bring the parties back to the procedure that we chose together. And the procedure was the following. Each party talks uninterrupted.
I did it.
And then the other party explains. So please, as you know, a pencil and a pad have been distributed to both of you. So while the other party is speaking in this very beginning of the session, please jot down any observation or remark you have, we will discuss it in detail, I assure you. So, thank you for this. And now, Mr. Sharp, do you wish to elaborate on anything further, or?
I think the most important things were said, but right now I'm the only one who works for the company, who earns the money. So I think I deserve 70% of the profit, and I think we are not ready to cooperate. Yeah, 70%. Yeah, that's the thing.
70%.
Yeah,
like
7%.
7%. Like 7.
Yeah, I know the
Or 1
the number. Yeah,
Because it's not 70. I'm sorry, it's not 70 that you deserve.
70 is 70.
No.
Yeah,
You
I'm
don't deserve
You
the
have to
70.
see it. You know it.
I do not know anything that's
So
not
now
based
you
on
know.
the facts.
Now you know.
No, I had shown
So
the facts.
could you just tell her that make some notes or something? I'm the one who's in charge right now.
Tell both of you that we should stick to the procedure. I know it's hard. I know you mentioned, both of you actually mentioned, even though Mrs. Smith still hasn't got the chance to explain her perspective, you mentioned this communication discrepancy between the two of you. It is visible right now, and I see it's difficult to start discussing in such an informal manner through mediation. But please, let us try in the beginning to stick to the procedure tightly. And Mr. Sharp, could you just continue if there's anything else you'd like to bring about?
Maybe that's all. I'm just the one who's working, so I think I deserve 70% of the profit.
All right, so to echo what you said and what I think grasped from your presentation, and to recap it, you are concerned that there is unequal division of labor within the company.
And profit.
And even though you noted that prior to the discrepancy that occurred 1 year ago, everything was functioning, or if I quote you here, working perfectly. So right now, of course, matters altered in such a way that you would like to sell the company and to divide the profit 70 to 30. Is this a fair recap of what you...
I think it's not only fair recap, but fair settlement as well.
All right, so thank you for this. And now I would like to ask Mrs. Smith to present her perspective.
Well, there's not much to say. Thank you for that. And yes, it is. It was and it still is very harsh for me to be here to address those issues. But we are where we are, and we need to confront what brought us here today. I can agree that yes, we initially were very profitable, shareholders of no need to pay LTD. We set it up as a business adventure, I would say. Part of the business plan at the beginning was that what we'll be doing is tax consultations, and yes, Mr. Sharp, all acknowledgement to him, is good at that. I'm also good into this. So we were having clients and servicing them with our tax optimization structures. But that was at the very early stages of the company's development. Later on, we moved on to the real estate management. And today that's like another aspect of the company. I would say like a separate division. It's like a subdivision of the company, an entirely different business from tax services that we used to, and we still are providing. No question to that.
I am providing.
And that's today.
Yep.
But in addition to today's work, we also have trainings for tax professionals, and that's entirely on my shoulders. This is part of the business that I'm in charge of, and I think that perhaps because Mr. Sharp doesn't get to see it day to day, he probably doesn't even know that it exists. But if you look into the accounting, you would see that a lot of the cash flow comes from those trainings that we provide for tax professionals.
No, sorry, Mr. Mayor, but I have to say something about that because I have the documentation, the tax documentation. There's no profit, no huge at all huge profit from this branch of our enterprise company. Nothing. It's the 30%. This is okay. 70-30. I don't have a problem with that.
Because I've heard the 70% number before. Like this has been on the table always, and I don't see it. Like for him, it seems like everything's about money, like money, and no intention whatsoever to look into the matter and where we are. We have a potential with this company. He just doesn't get to see it because he doesn't.
Company.
I can disagree, but because I've heard you argue many times the 70%, and I've never heard even once for a change any argumentation of the basis that you used to come up with the number.
Did you see the numbers? The profit of the company?
See the numbers.
The client,
But
the
what
money
I
that
also
clients are
saw-
paying.
And you may
Did you see
be
that?
interested in seeing this document, and I'm sure that the mediator is going to be interested. This is evaluation of the assets we hold.
Well,
And
I
it
have
actually
all the
gives you-
documentation that we need,
it
and that
gives
is saying that more than 70%
a
of the
precise
profit
idea
goes
of the
from our
cash flow.
clients.
Where
That are
where
my
are
business.
those clients? I don't see them.
Well,
I don't see them. I don't see clients.
Maybe
I
you
don't see
should
clients.
leave the houses and sometimes go to the office and see
Okay, you have
the
the guts
people.
to tell me this? No, that's absurd.
That's the situation.
So, anyway,
See the account. See
what
the
it- okay,
account. Who's paying for our bills?
okay, I'm not going to go.
Yeah, this is the
I'm
point. You're
not
not
going
going.
to go to your road. So, my suggestion is, you don't want to work with me? Fine. I don't want to work with you either. Okay?
Perfect.
We can agree on that. What we can and should agree then is how we part. And I suggest we part with grace, which means sticking to our initial word, which is 50-50.
But the situation changed
That's
a
the
lot.
profit division we agreed
But
on.
from the beginning, it was 50-50. I agree. There's no
I don't
reason not to agree. But right now, the situation completely changed. I am earning more than 70% of the profit of the company,
No.
and you are getting 50%.
Now,
Doesn't
if I may
make
step
sense.
in, just Mr. Sharp, please consider the initial procedure that we all agreed on. And just as I asked Mrs. Smith while you were talking, I would also advise you to jot down any remark that you have. We will discuss it in detail. Just let Mrs. Smith, should that be all right for you, to continue with her elaboration. So what else do you wish to share at this point?
I don't think there's much more to say. You see the exact status of our communication, and it's been like that for the last 12 months. So obviously we cannot work together, and I can agree that if you want to put an end to the business, all right. I mean that's where we are. Fine by me. But what I cannot agree on, and this is my position, we may discuss if we want to continue and how we want to continue, if that be the case. But if we are not to proceed with the business, and if we're to liquidate no need to pay, I'm very, very much, I cannot agree to his 70%. My position is we stick to the division of profits 50-50. That was the initial plan. I'm not requesting for more because I trust that part of that share, I have grounds to ask for more than 50%. But I have the honor to say that this was the initial plan and this still is the plan. So that's my position.
All right, thank you, Mrs. Smith. So I actually thank you both for your patience,
React
for
somehow.
your elaboration. Please.
She's acting like a generous lady, but she's
Who I
not
am.
generous. She wants 50% and she deserves 30 maximum. So it's very easy to prove it. She said she has some text
Okay, go
documentation.
prove it in court, okay? I mean, if that's the conversation you want to lead, go prove it in court. Okay, I'm fine.
But
Go prove it in court.
then this session is useless
Well,
if
I'm
you're saying
sure that
this
we're
way.
coming here to have some discussion, right? I mean, let's
We-
listen to him for a once, okay? He may have something to say.
I just,
No, let's
as you said,
let
you
him
have the
continue with
documentation. I
with
have the documentation
process.
as well. So let's see the background and say, okay, you are earning this money, you are earning this money.
All right, I know, first of all, I understand that all of this is very, very hard for you after 1 year of turbulent communication or lack of communication to sit here at the same table and to discuss these matters with the help of a third party. I understand it's hard. I also understand that you came here quite prepared with the relevant accountancy documentation that we may easily delve into, should that be the way you perceive this negotiation today. Yet once more, I urge you to stick to the procedure that we chose and to try to go patiently through all the topics. For instance, at some point you started discussing the 30 or 70% or the equal division of the profit from the company should it go liquidated. Yet this is a solution to one of the two scenarios that you perceived, which is either continuing with the company or not. So let's just go patiently through all of that. And before we do it, let me just recap what Mrs. Smith just shared with us. And it is briefly the following. Please correct me if I'm wrong with anything. But from what I grasped, you perceive that there is equal division of the workforce within No Need to Pay Limited, that with view to the sub-branch of the real estate and to some other occupations and obligations of yours, you deserve to receive, should the company be sold, an equal amount of the profit. And you also mentioned, just as Mr. Schaaf, that communication is a very important matter in your commercial cooperation. So, what my experience tells me is that it's also always very good to have some plan or some agenda to give structure to our discussion, to give some firm ground beneath our feet. So, to help you with this, I came up with three main topics from what you just shared, three main topics that seem to be utterly important for the two of you today. And these are the following. First, of course, your shareholding within the company. Then the second topic would be the possibility of future business together. And of course, the third matter, communication, the word we keep repeating throughout this session. So can we consolidate that these three topics represent a fair recap of what we ought to discuss today?
I can agree to that here. Yeah.
So should this agenda be also all right for you, Mr. Schaaf?
Yes, but I don't think we are able to cooperate in the future. But if you want to make the agenda like this, I don't have a problem with that.
We can just put it down on the flip chart just as a possibility.
Okay, then I'm okay with that.
So now that I mentioned the flip chart, one of the most useful tools in the toolbox of the mediator, I would like to write down the three main topics in this agenda that we consolidated on. So one of the topics could be the shareholding of the company. I just write down shareholding. And is this visible? Another topic may be the so-called future business together. And in this ambiance of mediation, I take the liberty to underline the word together. And the third theme, the third important topic, which you both considered as being very, very important for you, would be the communication matter. So, as you can see, I'm deliberately abstaining from enumerating the topics. You may conduct your negotiation in any manner you want. This is just to give some structure to your dialogue. So, this is the agenda that we jointly came up with. So now, as I told you, I have not enumerated the topics. It is entirely your joint choice to choose how to proceed and with which topic to enter this discussion. Please.
So may I suggest we start with the communication? I believe this is the root of our problem. I believe communication is also the way to solve our problem. And I think it would be very useful to really have a way of communication, a way of listening to each other, a way of hearing each other, a way of even being heard. So I suggest we spend some time on this because...
All right, how do you perceive this, Mr. Schaaf?
I don't think it's necessary. It used to be very important. We cooperate. Right now, we're not cooperating anymore. So
how are we going to solve the problem then if we're not able to talk?
So you have numbers, I have numbers. We have a mediator, so we can just make some ending with that, just to say how much money I get.
But
that's all. It's about business, just business. We don't need to talk about this.
It looks like we have an invisible elephant in the room and we are not allowed to speak about it. Then what are we doing? We're not addressing the issues at hand.
Well, we're speaking about what you do, what I do, what you deserve, what I deserve. That's simple. It's business. This is the thing that I can. No communication. It's important, I know. It used to be much more important. It used to be friends, but right now, it's not important anymore. Right now, I just want to finish this thing, to sell the company, get the money, put my energy, my time, and the money I earn or I get into something else, something much more important for me, much more personal for me.
Yeah, but we're friends, come on.
We used to be friends. The last year, you saw the last year. every single
Yeah,
conversation.
you're not making it
means
easier for me.
I just want to settle it down. I need to settle it
But
down.
you cannot separate things. You cannot separate personal and business. Yes, in an ideal world you can, but they're intermingled into each other. So if you have something personal that I'm not aware of, I cannot be of assistance to you.
But I don't want to talk about this.
Mr. Sharp, I understand it may be difficult to delve into personal matters, and I just wish to underline once more that we are not in a courtroom, that we are in this informal ambiance of mediation where you could disclose anything you deem necessary, and it will remain completely confidential. So I know you disregarded at some point the importance of the topic of communication. Yet, in the very beginning, both of you shared that something changed 12 months ago, that something changed dramatically after many, many years of successful commercial cooperation. So, you, Mr. Sharp, from what I grasped, mentioned some personal matters and that you don't have much time right now to devote to the company. Could I just go, if that is comfortable with you, a step further just to make sure that we are on the same page? And to ask what it is that, just very generally and broadly, that you need to devote your time and financial resources to presently.
Oh, sorry, Mr. Mediator, but I don't want to talk about this. It's very sensitive for me, and experience very hard days, or months, maybe a year. So no, I don't want to. I don't think it's part of this. I just want to finish it, get the money, and work on other things that are much more important for me. Maybe the most important thing right now. This is my goal, and I don't think it's connected with the business.
I do respect your decision, Mr. Sharp, entirely. I do understand that you may be in a difficult situation you don't want to delve into. Now, what I did tell you in the very beginning is that at any time during the session, you have the option to adjourn to a so-called caucus or a private session with me. And I do believe that now would be a suitable time for us to adjourn to such separate meetings. And how do you perceive this as an option?
Well, if you think it would be useful for...
Indeed, I do. So, Mr. Sharp, I understand entirely that it may be difficult for you, yet...
for sure, it's very difficult, but if you think it will help us and lead us to some settlement, and then
Indeed. I think it will be the perfect solution to this impasse and walking in circles that we found ourselves in the very beginning of this discussion. So, Mr. Sharp, I know it's hard for you. Maybe we could, despite this, begin with a separate session with you.
Okay, let's do it.
Thank you. Mr. Sharp, please make yourself comfortable. Thank you once more for choosing to adjourn with me to a caucus, to agreeing to this private session. Now, in the beginning of your negotiation with your partner, Julia, you mentioned that
I found this information. I have only one option, and this is the health of my daughter for sure. So I tried to find some. Sorry, I will drink, please. I tried to find some solution, and they said that I can take care of my child at home, but it takes time, and also some changes in the house must be done. So I said, okay, I will do anything for my child. So I just tried to find some possible solution that cost a lot of money. It costs for the medicine, for the doctors, for the adjustment of the house. So the only option for me is to stop the business, sell the business, get the money from that, and take care of my child, for sure. So that is the reason why I need the money. I know that Julia used to be friends, and maybe it's not really family, but they're very close friends.
Mm.
And after I realized that this problem, this possible complication of my daughter, I wanted to talk to someone. After the beginning was, you can't even imagine what happened if the whole world, the whole life just changed like this in a very, very, very bad way. So after a couple of weeks, I tried to talk to her and just to explain what happened and what I'm experiencing. But it's impossible to talk because we are just arguing all the time. I'm just trying to say something, and she's talking about business, which is not important for me at all right now. I just want to take care of my child. And that's all. So this is it, maybe. You can. So this is sufficient for you.
Mr. Sharp, it is more than sufficient. I just wish to say, firstly, 2 words, and thank you. Thank you for choosing to speak about this personal trouble of yours in a manner that is so direct and so honest. I believe that honesty is the key in mediation, and especially in this case, with you and Julia, who have cooperated successfully as friends for so many years, honesty is the only right path. And I thank you once more for this. You are in the most difficult situation imaginable. And now it is more clear how what motivates you to, and I'm making a short recap here, to choose as an only option to sell the company and to devote all your time and energy to the healthcare of your daughter, specifically by meeting the doctor bills and also making some necessary house adjustments that you also mentioned. So I said that honesty is the key. Do you think that when we go back to the joint session with Julia, if you choose honesty one more time, and if you share this personal issue with her directly, just as you did right now, this may change the whole climate, the whole negotiation climate in the room. Would that be an option for you?
Well, it's hard to say. I tried a couple of times and then we know each other for a very long time, so she has to know that something is happening. I had to change somehow. I'm not joyful anymore and all this jokes, and it's not working anymore.
Indeed.
So I tried, didn't work. So if maybe, and it will be hard for me, but if you maybe help me with that, and could you just tell her by yourself?
I will begin presenting this personal matter, yet I feel strongly that it might be best if it comes from you, Mr. Shah.
Mm-hmm. So if you think it would help, I can try it, but still it will be difficult, and I have to say I'm a little bit afraid of the results. It's still hard for me to talk to anyone, especially to Julia, about this matter.
I understand clearly, and with due to that, thank you once more for making this choice of sticking with honesty when dealing with your business partner. So, is there anything else now that we are in private that you may wish to share with me additionally?
I don't think that will be anything else. this is it. This is all the case is all about this.
Thank you, Mr. Sharp. Then I would ask you for some patience now while I hold the separate meeting with Mrs. Smith.
Okay, thank you.
Thank you. So, Mrs. Smith, please make yourself comfortable. Thank you for agreeing to adjourn to this caucus. Now, at the outset of our private session, I need to underline that everything you share here shall be regarded by me as strictly confidential, unless, of course, you instruct me to disclose it to Mr. Sharp. So, now that we're in private, is there anything that you would like to discuss? Anything you would like to elaborate on that you didn't have the chance to talk about during the joint session?
Thank you for giving me the chance. Well, in reality, and as I said, I do believe we have a communication issue, and I see it very clearly now that he's troubled, and this troubles me as well because I still deem him as a friend or somebody close. So the mere fact that he wasn't comfortable sharing it out loud is pretty troubling, which indicates to me that we have a lot of work to do in order to reach a sort of a solution. I'm hoping that you manage in the private time that you took with him to really open him up a little bit, because I believe what happened 12 months ago has an impact today. And for me, it would be important to get the understanding so as to be able to find a solution. And we'll see. I remain open for that.
Yeah, it was very transparent in the joint session, and right now it's also quite lucid that for you it is important to clear out the matter of communication firstly. And I have positive news with regards to this. Indeed, in the private session, you guessed correctly, Mr. Sharp agreed to discuss some very personal, very emotional matters, to discuss them openly and in an honest fashion with you during the joint session. So I have the strong belief that this would alter instantly the whole climate, the whole negotiation climate in the room. So, is there anything else that you want to talk about now that we're in private?
Yeah. Well, first, that's great news. That's great news because I believe that's the key to finding a solution. And as part of the solution, something that I'm ready to share with him is that I'm really, really willing to continue with the business. So my proposal to him would be to buy him out. I see that the business, as much as we have had our challenges in the past, it is something I want to devote myself for, and I clearly see that he needs the money. So from my perspective, we may have a settlement there. It's just a matter of finding the right price for the buying out of his shares.
So from what I grasp, it is an adequate commercial option, a business option for you to buy out the share of Mr. Sharp. And a follow-up question, is it okay for you to present this as an idea during the joint session?
Well, I would first wait for his opening,
I understand.
because I think that might have an impact on whatever solution we come up with. But afterwards, I'll absolutely feel comfortable sharing it with him, proposing it directly with him. And of course, I would rely on your guidance and assistance to help support me in this and to probably find a way out.
Let's hope you do. Let's hope you do.
Optimistic about it.
So, provision obliges me to ask you whether I could share this with Mr. Sharp.
Yeah, please do so.
Thank you. So, let's now go back to the joint session. Thank you.
you.
So, Mrs. Smith, Mr. Sharp, thank you for your patience and also for your very active participation in the private sessions with me. I think those were very useful in that, for instance, with Mr. Sharp, we managed to tackle the very sensitive topic of the personal reasons for his preference to discontinue his commercial activity within No Need to Pay Limited. So, Mr. Sharp, as we discussed, you're in quite a difficult personal situation, and there are matters that you find hard to openly share. Yet during the private session, you made the firm choice to try to explain the situation to your partner and your friend, I believe, Mrs. Smith. So now that we are back together, could you please elaborate on this?
It will be hard, but I can try at least. So the situation that brought us here, you remember Lily?
Of course. How is Lily?
Not
Did
very
you
well.
speak about her?
Well, the reason is she's not very well. She's ill for a couple of
Oh
months
God.
right now, and right now I'm taking care of her most of all
Understand.
because there are some serious problems.
Oh,
She's
sorry to hear it.
it's a very very hard situation for me and for her.
I can understand
It's
that.
very so I'm not able and, to be honest, willing to put my energy and the money and these things into
It must
anything
be
else
very
than
hard for you.
than Lily. So this is the reason why I have to finish the whole company to get the money, because it will cost a lot of money and personal energy, time, and these things. So this is at the beginning of our situation.
So you need the money to support Lily, and you
For sure,
need the
to
time
take care of her. Yeah,
take
because
care of
I'm
her.
according to the doctors, I'm able to take care of her and not leave in the hospital, but take it to my home. But I need to make some changes in our flat or house, and also take care of her by myself. So this is the reason I was not able to tell you and why are you here.
Yeah, and I'm really sorry about the situation, and
Thank you.
I'm sure how difficult it is and how depressed you might have felt, and now sharing it with me, I understand how frustrated you were with the situation, and just let me know what I can do, and then
Well, if we can handle this thing, and just to
I'm sure with
make all these things must be done for Lily, I would be
yeah.
really grateful.
Well, this entirely changes the scene for me. I now feel totally different, and of course we will find a way out so you can take the care that you need to, and at the same time we can just find a solution to the issues that we already raised.
Hope so.
Mr. Schaap, I do thank you for speaking about this in such an honest manner, and Mrs. Smith, thank you for mirroring this with so much empathy. Now, to give you some structure, from what you shared, on the one side, an important topic presently in your discussion would be the money matters regarding the healthcare of Lily, and also the necessary house adjustments and the resources that need to be allocated for that. So this could be one of our two new topics on the agenda. And also for Mr. Sharp, from what I understand, your most preferable option and business path would be to discontinue your activity with the company. So maybe a second topic could be the company with two possible commercial scenarios before both of you. One of them being to sell the company, and the other being to, and with this I'm nodding to what we discussed in our private session, Mrs. Smith. The second option could be to not sell the company, and there you perhaps would need to elaborate on the specific conditions under which this business scenario will transpire. Is this proposal for a new agenda satisfying for you at this point?
Yeah, I just want to make one side comment, maybe just one addition to this. I already spoke with Georgi about it during the private session, but what I can propose as a way forward is to buy your shares out. I think that may be the fastest way forward, and it would allow you to focus immediately on the most important thing, which is Lily. So take it as a proposal from me as to the options. And I would like maybe to explore this a little bit further if you agree that such a course of
Well, it's new information for me. To be honest, I don't too much care where do I get the money. I just need to take care of my child. That's all. That's the only thing I need and want. But if it would be suitable for all of us, then I would be happy if you continue with the company, because we worked for years in that, and
Absolutely.
it's working very well. So I would be happy to let it be led by you for sure. But
Great.
it depends on the conditions that I have to the final settlement that I need the money and
So
arrange to care for my
you
child.
said it depends on the conditions, so let us explore together these conditions. And I again turn to the flip chart just to jot down the ideas for topics that we brainstormed. So from what we just discussed, I believe we could consolidate on the topic of share, transfer, and specifically on the price for that. So here I turn to you, Mr. Sharp, and I pose the following question. You mentioned that you need to meet some medical expenses on the one hand, on the other hand, some costs for house adjustments. Could you present to us specifically the exact numbers and for each of these different obligations?
So the obligations right now are two of them, and the first one is the doctors, which will cost 30,000 euros.
So I put down bills and the sum of 30,000 euros.
And also we have to pay in a couple of days or weeks 75,000 euros for the medication and other related things.
Okay, so we could put down, if this is okay with you, medication, and the number is 75,000.
Yes.
Thank you.
And the last and the biggest are the house adjustments, which will probably cost around 220,000 euros.
Okay, so we can write down house adjustments, 220,000
Yes. 1,000 euros.
All right. Well, you are the business people, so it is your task now to talk in numbers. So, Mrs. Smith, how do you perceive these expenses that Mr. Sharp presented?
Well, I see that the expenses total to the number of 325,000 euro, if I'm correct in my
Indeed.
calculations. And unfortunately, I don't have that amount of money. I don't have 325,000. The biggest that I can pay to you is 275,000. So there is a difference of 50,000 that we are apart from each other.
But
What can we do with that difference? I mean, is there any way we can?
Well, this the expenses I have to spend for sure.
So when do you need the money for? When do you need it by? Is it due now, or you can?
The first two, yes, the bills must
Okay.
be paid in 1 month or something like that.
Okay.
And the house adjustments, it will take some time, definitely. So I have to prepare the house for Lily like in half a year or something like that. But part of the house is supposed to be done in 1 month maximum, just to take her home.
So within a month, you need 105,000 euros.
Yeah, that's the bills.
Mm-hmm.
And make the first changes in the flat. It will be like a month and a half. But not that's not the biggest reconstruction, but part of it must be done in 1 month, 2 months or something like that, which will cost some money.
But just for me to understand, and real estate management, I'm in that business. How did you come up with the number? I mean, did you have your contractor that
Not yet,
has given you those?
as you can hopefully understand, I was completely depressed and I'm taking care of Lily. So I just asked some friends or some companies, show them what I have to.
Why don't I help you here? I mean, that's my field. That's my expertise. I mean,
it's new information.
This is absolutely. I'd love to. I'd love to help you. And quite honestly, I think that this. I know your house. I think this amount for refurbishment is a little bit overrated. It could be.
Well, I'm not professional in this thing.
So I think we can reduce the actual number. So if I got my the partnering countries companies that we actually use for our business, I think we can pretty much reduce the number and then.
Well, to be
working
honest,
with-
I don't too much care who's
It's-
going to do it, and I don't need the money. It's not money for me. It's money for the adjustment. So if the changes will be done
Well, then I think-
somehow,
Yeah,
I don't
yeah.
care how much that does it cost.
I actually right now I'm thinking I have like 3 companies that are pretty good. I'm sure they'll make a great job, and actually the pricing would be far lower than this number. I'm
So-
certain about it.
If you arrange it, if you are able to
Yeah.
assist me in this or arrange this thing
Absolutely.
or
I'll do it
make
with
these
Lily as
changes,
well.
then I don't have a problem with that.
Super.
It must be done. This is the only option, only goal I have.
So then, what I will need from you is the floor plans and the specifics that you
adjustments.
need the house to be compliant
Well,
with.
I have it here, so I can send it immediately after
Okay,
our
just
meeting.
send
I will send it
just
to you.
send me the floor plans and
It's
requirements.
supposed to be done very quickly. Like
Okay,
we have to start in 1 month or something.
So maybe
Time
you
is of the
should
essence, yeah.
fix some deadlines, for instance, and appoint
Mhm.
another meeting.
Well, I would send it immediately. The information on how much time
Okay.
do the companies or your colleagues.
So
or
then I
whatever.
suggest, and what the mediator is actually kindly inviting us to do is, I will arrange all the contracting companies that we can use. I will speak with them. I will send to them the floor plans and the additional information that you sent me.
Mhm.
I will discuss it internally. It may be that they need to come and see the house just for a better understanding of what exactly needs to be changed. And let's meet 1 week from now with the concrete information,
No problem.
specific deadlines, designs, so that you can approve it and then we can go ahead.
I'll be happy to.
Now, first of all, just a step back. It's extraordinary how you face these communication discrepancies for 1 year, for whole 12 months. You could not communicate properly. And now just after some time in this mediation environment, you're discussing concrete proposals. So let me just make sure that we're all on the same page with regards to these proposals. So what you agreed on while analyzing the scenario in which Mr. Sharp's share is transferred to Mrs. Smith is the following. Mrs. Smith would pay the amount of 105,000 euros, which would be due immediately, as far as I understand. And also, she would undertake the obligation to assist Mr. Sharp in the refurbishment and the necessary house adjustments in the house of Mr. Sharp within the next month. So you would contact, you said that you would take this task home and you would contact the 3 partnering companies you're using to discuss the floor plans, which Mr. Sharp would immediately provide you with, and also the additional specifications that are required for your analysis. And you would present Mr. Sharp with an option, yet the cap sum, the total amount which you could not exceed, is the total sum of 275,000 euros. Is this correct?
That's totally correct from my side. Of course, I assume that if the total refurbishment is far lower than 275, then we just go with whatever the amount is.
Is this agreeable to you, Mr. Sharp?
Well, I have to have it done. This is the most important thing for me. So if it's going to be done, then I'm okay with that.
All right, then thank you once more. And I brought to the table the topic of specific deadlines and when your next meeting ought to be. You agreed to meet in 1 week. So my next question to both of you is, do you need my assistance and my presence during this subsequent meeting? Or do you think you could reason out the matters of house adjustments on your own?
Well, thank you for the offer, but I think with Julia we are
I
able.
think we'll be fine.
Hopefully, we are able to
Yeah,
settle it down.
we'll be fine. Thank
All
you
right.
again for asking. We'll keep you informed of whatever we
I would be
come with.
looking forward
Oh,
to,
yeah.
to seeing what you have agreed upon in the end. And now I want to thank you, Mrs. Smith and Mr. Sharp, and to wish, firstly, to Mrs. Smith, broad commercial horizons before
Thank
No
you.
Need to Pay Limited. And to Mr. Sharp, on the other hand, I wish sincerely a speedy and full recovery of young Lily. Thank you both. Thank you.
Thank you. Thank you very much.
55,000
€679, and that's the best that I can do. That's the price, and this is without.
Hello, Mr. George Elenko. Oh, Mrs. Smith. Yes, hello, hello. Oh, Mr. Sharp, I can hear you too in the distance. Yeah. So, how are things going 9 days after the end of our mediation session? You did agree. Well, you agreed on the house adjustments, the specific sums. Good. Excellent. I'm very, very happy and rewarded to hear that. Thank you. Well, Godspeed to you both, and thank you. Thank you to you too. Thank you. Good luck. Good luck.
We are back. Thank you so much for watching. What are your comments from the video? Any lessons from the video? Those who cannot talk, please put in the chat. Those who can talk, please bring it up. Any lessons from the video? Hello, are we there? Or because of the video, we didn't watch. We left the video. Am I audible? Can you
We
hear me?
watch. Yes, we can hear. Call your students by their names.
Those who are asking for the link to the video, we are unable to share the link to the video. It's on YouTube, so but we are not able to share. We can't share. Sorry about that. We can't share. That's why when I was going there, I showed it for you to see where we are getting it from, but we cannot be sharing.
It is classified information.
All right. So, all right. Some people are sharing. Someone said it was good and knowledgeable. Someone said little boring as well. Someone said one need a lot of patience to be a mediator. Okay. All right. So thank you all for bringing me the various perspective to the to what you watch. But we showed you this for you to process it in your mind as we take you through the mediation process. Then you look at what was happening in the video and bring it to bear what we are telling you and what was happening in the video. Then, if there are corrections to make, you do them, and you are able to become a better mediator than what you saw in the video. It's now 1:29. We're going to give ourselves 15 minutes break. We haven't had a break for today, so 15 minutes break for you to take water, walk around 15 minutes. So it's now 12 and 1:29. 1:22. We'll come back at 1:44. 1:44. We are back. So we are taking 15 minutes break. We'll come back, then we'll continue with the mediation process. So see you soon. Hello, welcome back. I hope you can hear me.
Yes,
Hello, can
loud
you
and
hear me?
clear. Loud and clear.
Okay, great. Welcome back. Now let's continue with the process. So the mediation process and strategies that as a mediator you can adopt. So process, as we are discussing this, process what you saw in the video in your mind. So let that be a picture within your mind as we move on. So this is a step-by-step process, a step-by-step mediation process. So the mediation process is a practical step-by-step procedure that help people in conflict to understand. So first, the mediation process is supposed to help the individuals to understand themselves, explore, and also develop solutions to disagreement or disputes. It is a map for resolution. So as you are going into mediation, this process, this step-by-step process, serve as your guide or as your map. It's like when you are sailing, you have a compass or you have a map. When you are driving to an unknown location, you have a map that guides you, turn left, turn right, go straight, in 100 meters, turn this. Those are the guidelines for you. But in the same way, as a mediator, you also have your map for resolution. So the mediation process involves preparation, time for the parties to meet, and then 5 other steps where it depends on the mediator can develop to adopt other steps, where people involved in conflict work together with the mediator to identify or build a mutually acceptable agreement. So you work together with the parties and agree on a mutually acceptable agreement. So one, preparation stage. So preparation is in 2 folds. You, the mediator, preparing on your own, building your capacity, reading about the subject area, gathering enough information so that when the parties are talking and sometimes they mention certain things, you will not be ignorant of those things. So you have to thorough understand the issue. So what are the issues that at stake that you, the mediator, is going to help the parties? Sometimes it's not about the issues understanding. It's not always about understanding the issue, but sometimes when the people are talking, if you understand what is at stake, you can ask certain clarifying questions for a better understanding from all the parties. So before mediation session, gather comprehensive information about the parties involved. So who are the people that you're going to meet, their concerns, and the underlying issue. So you must understand their concerns and the underlying issue. Then also establish goals. Clearly define the objectives of the mediation. You, the mediator, why are you there? What are the objectives of doing that mediation? Define your clear goals. Clearly define the objectives of the mediation. Your role is to play a neutral role, impartial role, and make sure that the mediation achieve the results that will be mutually acceptable by the parties. So by doing that, you are ensuring a focused and efficient process. A focused and efficient process. Then 3, select appropriate techniques. Then tailor mediation techniques to specific nature of the conflict. So when you adopt your techniques, how you ask certain questions, whether the question will be explanatory, will be direct, will be narrative, or what, depending on the nature of the issue. You may have a mediation that is distributive in nature. The people in it are people who are ready to lose or win. So they are the distributive that win-lose approach to the negotiation process. So you know how you can handle those people so that they can understand each other and will not be focusing on only about whether win or lose. Or integrative, if it is integrative and you meet people who are reasonable and they are ready to compromise on certain matters and collaborate with each other. You also know how you can handle them. So now, having done your preparation as a mediator yourself, now the next preparation that you do is to prepare the parties for the actual process. And that is what you, the mediator, do as an opening statement from you. So that is what we call opening statement in mediation. It is a ritual that you, the mediator, perform in the first time that you have met with the parties, so that the parties can understand what the process is, what to go into the process, your role, their role, and what must be done. Together, you can have a smooth process with the people. So at this point, so you have done your personal preparation, but when you meet the parties, that is where you prepare the party. So you are going to prepare the parties with your opening statement. For instance, welcome. My name is Isaac Asari. I am the founder and president of the African Center for Collaborative Dispute Resolution. You are welcome to the center. I am happy that you have selected me to be your mediator. May I know your names and how you want to be called? With me, for the purpose of this discussion, you can call me Isaac. Are you comfortable with that? Then you start having discussions with them, right? So that will be your first. So opening statement. So the first formal part of the mediation comprises an opening statement by the mediator. So you, the mediator. So if you look at the video, making reference to the video, opening statement by the mediator. So the mediator will address the parties. Experience indicates that this is an important stage of the process, particularly for first-timer clients of mediation, regardless of how much prior contact there has been with the mediator. So it doesn't matter how you have spoken with them on phone, how you have had several discussions with them on phone, or how you met them and the discussion that you have with them. It is a necessary thing for you to do and be able to do it properly so that the parties will be at the same level. And it doesn't matter where parties come, especially some of them may come and say that, oh, we understand mediation, we have heard mediation before, so mediator, go on with the process. Stick to the plan as a mediator, do your normal opening statement, explain the processes to them, and take them through the process. I'm not saying that there are certain, as you grow into the field, you realize that there are certain things, there are sometimes, some cases may come that you may then need to take them through all those processes because the parties have already maybe drafted an agreement that they want to go ahead and look at them. But there are differences. But the most important thing is, as a mediator, know that you are supposed to give your opening statement, then you create an atmosphere for a good discussion. That is very important and key. So once your opening statement is going to prepare them for the process. So set the tone. So your opening statement set the tone. So your opening statement sets the tone. It creates a neutral and a respectful environment to encourage open communication. So the way you talk, you receive them, the way you speak to them, the way you let them know that they have chosen the right path, it creates a neutral and respectful environment to encourage open discussion. And the fact that the parties know that whatever they discuss at the place is going to be confidential. It sets that a secured environment, and they are able to understand that whatever they share will not be discussed with the third party. Whatever they share is secured with the mediator. Then the environment becomes conducive for them to talk. Establish ground rules. So you establish ground rules. So you establish how things will go. the events of things and how when one is talking, the kind of languages to use, their body gets, all things and the rules governing all the processes are discussed at this level. So we establish a ground, define the guideline for the mediation process, ensuring a structured and a fair discussion. So making sure that if everyone is going to have 10 minutes to have their opening statement, they also get 10 minutes to have their opening statement. If everyone will have 10 minutes to present their case, they will have 10 minutes. That is important so that everyone will feel that they have been given equal opportunity and the process is fair to all of them. So function of does the opening statement have a function? Yes, it does. So functions of the opening statement, it allows the parties to settle in, put them at ease, as their role is limited to listening and provides a mini mediation ritual. So at this point, the parties are listening to you, the mediator. So their role now is to listen. It is to listen to you and is to put them being listening to and knowing what they should expect from the mediation and how the mediator is going to manage the process. It put them at ease. And it also builds rapport between the parties and the mediator. So it reassures the parties on their choice of mediation if relevant. So you commend them. So I must commend you for your commitment to mediation process and having selected mediation as a process for your dispute resolution. I must add that this is a good way that you have chosen to resolve your issue. And I believe and hope that at the end of the day, the two of you will find a solution that works for all of you. So you reassure the parties of their choice of mediation. Then acknowledges the significance of the matter to all of them. I understand or I share that this must have been a difficult moment, whilst I know that this is very important activity or issue for the two of you. I believe that if you are able to open up, you are able to share your perspective to each other, you'll be able to find a solution that works for all of you. Inform them about the nature of the mediation, the mediator's role and their role. So mediation, let me take this opportunity to talk about what mediation is and what mediation is not. Mediation is a process whereby me, as a third party, is going to assist the two of you to talk. You are going to do the talking whilst I'll be asking clarifying questions and assisting you to do the discussion so that we can get an outcome that works the two of you have agreed upon. My role as a mediator is to facilitate the discussion, and you need not to persuade me to agree on your point because I am not a judge to judge on who is right or who is wrong. And your role is to be the one to bring the points, to bring the discussion, to keep talking so that you can have a solution to the problem. Can be used to distinguish mediation from other forms of help or intervention like counseling and arbitration. So you can also talk about mediation not being counseling, mediation not being arbitration. You can explain it, the process to them. Then explain the order of event for the rest of the mediation meeting. So the opening statement is used to also explain the order of event. So this is part of the process that we are undertaking. This part is preparation where I'm giving my opening statement. At the end of the day, we'll go into a session which is called Uncover or storytelling, where the two of you will be asked in turn to share your perspective or your side of the issue with us. Then at the end of the day, we are going to create an agenda from the discussion that the two of you have made. And now we can use those agendas to search for options that will give us a possible solutions to the problem that we're having today. Any question? If there are no questions, please ensure that the process is flexible and if at a point that you need to take your medication, you are free to do so. You can prompt us or allow you to do so. If you have to visit the washroom, please, the washroom is on your left. You are free to do so. Then if I share and understand that you are all business people, so in a normal circumstances, in order not to allow somebody to record whatever that is happening, where recording is also not accepted during the mediation process, we would have encouraged that we take your phones to a secure place. At the end of the day, then you go for it. But since you are business people, we are going to allow you to use your phones, but put them on silent. When you have emergency call, please do prompt us. We'll let you go and answer such calls. Are we clear on that, please? Then you move on. Stresses the flexibility in the process. So mediation opening statement stresses the flexibility of the process, explain the rationale for the party statement, and provides an order for the presentation as I indicated. So parties will also have a chance to present their own statement. Then establish the mediator's control and the parties' commitment to the mediation guidelines, tabled manners for the meeting. So once you have put the ground rules to the process, you make the party commit to that particular ground rules for effective mediation. Allow the mediator to assist to establish his or her credential and trustworthiness. So the mediator can use this opportunity to also establish his or her worthiness or trustworthiness so that people can have trust in her. For instance, I understand why this issue may be different from what I've encountered before. I must say that I have handled similar disputes. Then I have, because I have been in the system, having practiced for over a decade, I understand some of the things that you are talking about, and I believe I'll be in a good position to assist the parties. Just like that, you establish your credentials, establish positive goal and optimistic tone for proceeding. So you establish positive goal and an optimistic tone. So when you talk about positive goal, it's not about promising them, but you let them know that they should trust in the mediation process and that the mediation process can give them the results that they are looking for. Then the opening statement helps to identify common grounds and common goal, encourages parties to actively participate, and reminds them that they are in control of the outcome, deals with confidentiality issues. So opening statement, one of the key things is that the opening statement from you, the mediator, your preparation to the parties, also stresses on the need for confidentiality and what the parties can share and what they cannot share. You stress on that whatever happens, the discussion that unfolds during the mediation process cannot be shared to a third party. Then confirm the mediator's neutrality and impartiality, establish that the mediator has authority to settle. Then clarify special conditions for mediation on the need for agreement to be reduced to writing. So you let them know that mediation outcome is supposed to be in writing where the parties will sign and you, the mediator, will authenticate it. You will sign as well. So I mean that you authenticate it. So it is important for parties to understand that any agreement that they will make without writing it down will not be considered as a mediation outcome. So it is important for them that if they are making any agreement from mediation, it must be signed, written and signed. Addressing any other formalities regarding settlement, for example, review or ratification that might be required. So when it comes to ratification or review, it depends on the system. If it is Every mediation center has its own rules and regulations. So their rules may tell you that when you come to the center, we must review your outcome. But in most cases, they don't review any outcome. Functions of the opening statement continues. There manages expectation, for example, by reminding that the parties that they might reach impasse and that compromise will be required. So one thing I must share with you is that at a party, sometimes you may reach an impasse. Impasse means that you may reach a deadlock where people are not ready to even talk, people are not ready to move forward. I encourage that when we go to that stage, you recognize it and being able to move on with the discussion. Then encouraging openness and information exchange. Then allows for clarification on the role of lawyers, witnesses, and other supporters, parties present, and those who may be at the end of the telephone. So we clarify the rules. So if you're a lawyer in the mediation, yes, you can represent your client. It is allowed for a lawyer to be represented, a client to be represented by a lawyer. It is normal. But what you cannot do is that if you are the mediator, you cannot do the mediation as a lawyer and at the same time take the mediation to court and enforce it for one. You can't do that as a lawyer. So the lawyer's role, let them know. If the lawyer comes with the parties, let the lawyer feel welcome. Let the lawyer feel welcome. Let the lawyer feel that yes, he's welcome to the mediation, he's welcome to the table, so that they don't put impediments in the process. So welcome, counsels. I am happy that you have followed your parties to come for the mediation session. I must say that this is well to see. And to see this from you, councils, I am happy, and council supporting people in AD, I'm happy that you have done this. You can use this and at the same time decide not to use their system to cook the food for your So the next one is allows for clarification on the roles of lawyers, witnesses, and other support parties. So parties may bring certain people. So you have to be tactical. Sometimes they may bring certain people which you may not need in the mediation. So you can find a way to remove such people. So sometimes you come and you call the people and you tell the people that yeah, you want to meet first with the parties and you come and meet the other people. Then you go in and meet with the other party without the other people. So in some cases, points are distributed in written form or shown on overhead projector. So depending on the people that are involved, you can show the points on overhead projector, or it can be presented through a written sheet. So sample of the opening statement. Preliminary, welcome introduction. So welcome to the mediation session. My name is Isaac and I'm going to be your mediator. Or you can say it in a different way. Hello, welcome. My name is Isaac. I am happy that you have selected me to be your mediator. You can call me Isaac for the purpose of this mediation. How may I call you? Are you also okay by first name? So this one, you can do it in a different way, but this is a sample for you. So welcome and introduction. Welcome to the mediation session. My name is Isaac Asari, and I'm going to be your mediator. You both know each other, but you may not know each other's solicitor. So this one, they brought a lawyer involved. There are lawyers involved. There are a lot of mediation that lawyers are not involved. So engineer Atipo, this is Dorothy Eshenu, who is assisting Elizabeth. This is Samuel, who is assistant Seth, who is Seth's solicitor. Please call me Isaac. Right, so this can be an introduction for people who come with a lawyer. Are you comfortable with first names? They can tell you yes or no. Then, before we get going, I would like to check with you about timing matters. We originally agreed to meet today for up to 4 hours. Can we all recommit to that? They can tell you, no, mediator, I have emergency I have emergency situation. I am unable to recommit to the 4 hours. I think I can do 3 hours. I can do 1 hour. I can do this hour. So if the parties agree to that, then that is fine. You move on with that. Then, do you have any parking limits? So depending on your jurisdiction, they may have parking limits or constraints. So you to discuss. Do you both have authority to resolve this matter today? It is very key and important when you are doing mediation. You find out from the parties whether they have authority to resolve this matter today. Because someone may be coming with representing a company. What is the position of that person and what decision can the person take for the company? So it is very important. So what we normally do is that if the person is representing a company, let the company write to the mediation organization or the mediator, indicating the level of authority so that the person can exercise such level of authority. So please take note of that. Or sometimes if it is the chief executive officer who has come, then that one you are good to go. So ensure that the person who is on the table has authority. Then extent of parties contact with the prior contact with the parties. So you have to let the parties know how you have contacted them and the discussion that you have had with them. So by way of background, Elizabeth, you approached me about having a mediation, and I spent some time with you, talking to you on the phone, and sent you some written information about mediation, and said I did the same with you. You both know that I have spoken to your solicitors by telephone, and I have received papers which you prepared for me. That is all the contact I have had about this matter, and I have had about the same access to both of you. So you see, this is it. Are there any queries about that? Then they will tell you yes or no. The nature of the mediation and the role of the mediator. So you have made the decision to come to the mediation yourself. So you are letting them know the voluntary nature of the mediation yourselves. And generally, this is a better way of dealing with the problem than going into battle. So that is a commendable start. Let me tell you briefly a few things about mediation, although I appreciate that you may have heard some of this before. Mediation is a structured opportunity for those with a problem to make decisions about it themselves. My role as a mediator is not to make those decisions for you, nor is to tell you what decision to make or to advise you on law or on technical matters. My role is to assist you along the way in your own decision making. Sometimes emotions or poor communication makes it difficult for people to deal with problems. The mediator's role is to guide them down the path of decision making and help them to avoid the obstacle and pitfall. Elizabeth said, you will be discussing the situation and making the decision, and your advisors will assist you in that process. Experience and credibility statement. As you know from the material sent to you, I have practiced mediation for 10 years as a mediator. Whilst every situation is unique, I have considerable experience of working through the kind of problem we will be discussing today. Then neutrality and impartiality. I am a neutral and impartial party in the mediation. You do not have to try and persuade me about the merit of your case. If at any stage you feel a lack of impartiality, please let me know. Then checking with understanding. The objective today is for you to make decision on the issue you are facing. And my role is to assist you in that process. Are there any questions? Then the parties will say yes or no. Then review of the mediation process. This is what will happen. You are previewing the mediation process. So this is what will happen in the mediation process. Shortly, I shall ask each of you in turn to explain to me your concern. So you explain to me direct your concern. This need only to be brief overview, as there will be the time later to go into the details. After you have each after you have each made a statement, I shall summarize it back to you, and then we shall confirm the matter in respect of which there are already agreement and what makes still require decision. So you see, you confirm it back to them. So if I understand you correctly, you mean this. Listen to the both of you. I realize that there are certain areas that you are talking about. Can I say A, B, C, D is what the two of you are talking about, like you saw in the video? Then he confirmed them on the chat. So I shall then write these issues on the whiteboard or flip chart, and we can use it as an agenda for the meeting. You then work through the issues on the board or chart, looking at the options for dealing with them and making as many decisions as you can. So you make the thing practical, flexible for the parties. Separate meeting, that is what we call caucusing. A normal part of the mediation process is for the parties or the mediator to meet separately with each of the parties. As you have advisors, I will meet you with your advisors and you're together. This gives me an opportunity to see how the mediation is going first. And secondly, it allows me to raise matters which have not come up when we were together. And also it allows the other party to also have a break and to think about settlement option. This is also a time to also allow you to think about things that you don't want to share at the plenary session or the joint session. It is also an opportunity for refreshment and to make any calls if you need to. Are there any questions? Of course, this is a flexible process, and anyone can ask for the adjournment at any time, any reasonable time. So you let them understand this. Then you check confidentiality with them. So I need to refer to one more matter before we begin or we get going. Mediation is conducted confidentially, which means that insofar as the law allows, I will not disclose anything said here today. I will be taking some brief written notes, but these will be destroyed after the mediation session and cannot be accessed by either of you. Mediation is also conducted without prejudice, so without any preconceived notion or basis, which means that should the matter go to court, which we hope it will not go to, then neither of you can lead evidence about what the other side said at the mediation or produce document which they made for the mediation. Do we understand all this basic principle? Please, if you do not, check with your solicitor if you require further explanation to this point. Then agreement binding when signed. As regard with the outcome, the situation today is that any agreement will not be binding until they have been reduced to writing and signed by both of you. Is that understood? Then the parties will say yes or no. So questions and commitment. Before we begin, are there any questions which either of you have about mediation generally or about what will happen here today. So here you can take questions. If they are not, then you move on. Then you move on to the signing of what we call consent to mediate. The opening statement and the ground rules and everything will be captured on a document that we call the consent to mediate. The consent to mediate. The consent to mediate. So let me show you a sample of a consent to mediate. Or as some people call it, agreement to mediate or mediation agreement. Well, when you mention mediation agreement, there are various forms of mediation agreement. There is a terms of settlement, there is a consent to mediate. Right. So this is the sample of consent to mediate. If it is coming from a court, it will be different. You will see the name of the court. So you see in the matter of alternative dispute resolution, then the court name will be there. So, but this one is for us as a private practitioner. This is our consent to mediate. You will see our logo. You will see African Center for Collaborative Dispute Resolution. In the matter of alternative dispute resolution into bracket mediation, AD Accra 2025, AD 2025 Accra. Between, so you put a date, so they have the case number between, so the person, the claimant name, then the respondent name comes. So when you come here, you see how it has been done, consent to mediate. Then here, we the undersigned parties hereby voluntarily agree to participate in a mediation session facilitated by a mediator from the African Center for Collaborative Dispute Resolution. We understand that mediation is a voluntary and confidential process aimed at resolving a dispute amicably, and we are willingly committed to engaging in good faith efforts to reach a mutually acceptable resolution, and agree to commit to the terms below as ground rules for the mediation process. One, that AfCCoD serve as our mediation center. AfCCoD serve as our mediation center to facilitate the mediation process. Two, that Mr. Ezekasari, a mediator from AfCCoD serve as our mediator. Three, we acknowledge that the participation in this mediation session is entirely voluntary, and we have not been coerced and compelled to attend. We understand that we have right to withdraw from the mediation process at any time without prejudice. We also further agree to maintain confidentiality of all this discussion, documentation, and information shared during the mediation session. We understand that the mediator is bound by confidentiality and will not disclose any information shared during the mediation without our consent, except as required by law. 7, we commit to participating in the mediation session with honesty, openness, and sincerity, to desire to resolve our disputes. 8, we understand that the mediator is impartial and neutral and will not take sides or impose a solution, but will facilitate the constructive communication and problem solving. 9, we understand that any agreement reached during the mediation session will be voluntary and based on our mutual understanding and consent. 10, we acknowledge that the mediator does not provide legal advice or make decision for or make decisions for us, but will assist us in exploring options, reaching a resolution that meet our needs and interests. 11, we agreed to participate in the mediation session for the designated duration, to adhere to any guidelines or rules established by the mediator. 12, we understand that either party may request to terminate the mediation process or the mediation session at any time, and the mediator may also terminate the session if he deemed necessary. 13, that both parties agree to explore caucusing whenever necessary during the process. 14, that the mediator by virtue of his or her role shall under no circumstances be or serve as a witness to any of the parties in this matter, nor be used in any court of law for his role as a mediator. 15, that the cost of mediation shall be this. So you put the amount there, and it will be jointly responsibility of the parties. That each party shall pay 50% of the remaining fee. That each party shall pay 50% of the mediation fee. The mediation fee shall be paid before the commencement of the mediation. That when the mediation breaks down, the mediation fee shall not be refundable. That both parties agree to respect and comply with the undertaking and the process, and the outcome shall be binding. So you see here, claimants. So the claimant, sometimes they are more than one, or they will bring a witness, the claimant and their witness, or the claimant and the lawyer they sign. Then respondent, the same way, respondent and their lawyer will sign, or respond another person. Then we have the mediator. The mediator can be co-mediator. So if this one is for co-mediators, but if it is one mediator, this will not be there. So remember that, see the way the mediator one is, you see only the signature and the name. There is nothing like address, information, and everything. For the mediator, you are not supposed to establish contact with the people that you have resolved their matter for. Right. Any question on this form? Okay, no question. Then let's go back to our presentation. Are we there? Any question up to this stage? Are we there? I want to hear from you. Are we there?
Very well understood.
Okay, let's go back. So that is where, having explained having explained everything to them, so you sign the consent to mediate with the parties. This is when you have met them and they have not signed the consent to. There are instances where you meet them, they have already signed consent to mediate already. There are instances where when you meet them, they have already signed the consent to mediate already. So especially those who are in the court setting, they might have signed the consent to mediate with the registrar or the ADR officer at the court or there may be also a mediation office where the office has also arranged and manage the pre-mediation session and sign the consent to mediate with the parties. So when you go, the most important thing is take them through the process. Take them through the process and make sure that they understand all the aspect of your opening statement. Don't say that they have already signed the consent to mediate with them, so we don't take them through the opening statement. We just go straight. No, you have to make sure that they have signed the consent to mediate and everything. Then, so signing of the consent to mediate, if you are managing it as a solo mediator where the parties, one party met you and the other party also came in, you contacted the other party and the other party agrees to come, then it means that you are the mediator. They accept that you be the mediator. You manage it to a point where they will all sign the consent to mediate. So as indicated to you earlier, your commitment to the process, I have reduced all the things I have discussed with you into a document called consent to mediate. This document gives me the authority to sit with you and have this matter resolved. Both parties will sign and I also sign. You can go through the points by step and sign. Right. So when you finish signing the consent to mediate, that can be one, after discussing the consent to mediate, your points and everything, that can be one meeting, depending on you and the people. It can be one meeting. So having signed that with them, having signed a consent to mediate, now you transition into the parties' statement. So now you are now going to give the baton to the parties for them to give their statement. You give the baton to the parties to give their statement. So you are going to give the baton to the parties. Now they will give their statement. Right. So the next one is transition to parties' initial statement. So thank you, Elizabeth. Can you tell me what your concerns are here today? And the same to the other party. So Elizabeth, tell me, Elizabeth is the one who brought the issue. So having signed the consent, you thank them. Thank you for going through the consent mediate and signing. Now, can we proceed with the mediation, or you want us to meet another day? They may say that, oh, mediator want to go on. So you thank them. So thank you. Thank you, Elizabeth and Seth. Now, since Elizabeth is the one who brought the issue here, I will ask Elizabeth to speak. Then you also bring your side as well. So, Elizabeth, can you tell me what your concerns are here today? And the same to the other part. Right. Then, delivery of the mediator's opening statement where there are two or more mediators. So, when it comes to delivery of the mediator's opening statement. So when you are preparing the parties, what if you are two mediators? What do you do? So if you are two mediators, there should be no sense of hierarchy between the mediator and the co-mediators. So the party should not have a sense that there is a mediator and there is assistant. No. If it is an observer, then let the parties know that this person is just observing the process and the person will not take part. But if the person is a co-mediator, there shouldn't be any hierarchy in the mediation. So there should be no sense of hierarchy between the co-mediator, which entails that they share the statement, not leave or most of it to one mediator. How they divide it is up to the matter of logic, convenient and training, subject only to the necessity of the operating of as a team. So we must be able to, it doesn't matter if one person is going to present the opening statement, but you must operate as a team. It should be a teamwork. It shouldn't be just one person dominating the mediation aspect. Because a division of tasks is more important during this stage of co-mediation than in later stage. So co-mediators require a clear understanding of who will say what and what the accused are in order to operate as a team in delivering statements. So it's very important to note. Question arising out of mediators' opening statements. So questions arising out of mediator's opening statement. So you, the mediator, after you have explained the process and everything to the parties. So I think before I go there, I think somebody has asked a question. He said that who qualifies as the claimant and who as the respondent? So when it comes to mediation or in ADR, we talk about claimant and respondent. As we go to court, you have plaintiff and defendant. But in ADR, we call them claimant and respondent. The claimant is the person who brings the matter. So the person who initiates the process. So whoever initiates, like if you go to court, the one who initiates the plaintiff. Yes, so whoever initiates the process is the claimant, and the one who is supposed to respond to those claims is the respondent. Then he said, on what basis is one disputant considered as a claimant and other as before? Okay, I think you have answered that. Then the next one is it not the case that both of them work to the settlement request for mediation? No. It will be rare to find. Let me say it will be rare to find that two people will walk into your mediation center and say that we have a dispute resolved for us. It may be impossible. It can happen. So it happen if it is 100%. You can say that 1% may happen, that the two of them will come. So when the two comes, they become disputing parties. So you just write between their names this and this. Don't apportion anything to anyone, whether party A or party B. Just their names, A and B. That's all. You don't apportion this one as claimant or this one as respondent because it is the two of them. But if a court refer a matter to you, the title on the case remains unchanged. So if it is a court, the heading remains unchanged. You only add the ADR session. Then in the matter of utility dispute resolution mediation, you add only the ADR session, but the title in the district or in the higher court of adjudicator or whatever, it doesn't change. The case numbers and everything will be there. So those are the things. I hope I've answered your question. Question arising out of mediator's opening statement. So opening questions asked at the invitation of the mediator. For instance, after giving the opening statement, you can ask, are there any question that is bothering them? So they can ask you a question. At the end of the mediator's statement, there should be dealt with as clearly but briefly as possible. You must be clear and brief as possible. Don't try to whine in and going in circles. Just be straightforward and tell them what is it and what is not. Don't be running in circles. Solicited or unsolicited question during the presentation of the statement can be dealt with there and then in like manner. Some of the questions too, you don't let it to slip off for you to finish. Sometimes once you are explaining certain things to them, they just decide to ask certain questions that you have not even solicited for it. You must take your time and explain to them as quickly as possible. A delicate balance is required during between satisfying the needs of the questionnaire on the other hand and avoiding over-elaborated answers and delay on the other hand. So it is important to balance the situation. Omission from the mediator's opening statement. So omission can also occur once you are explaining. The things may be long and you may forget to add certain things to your mediation. It is normal. So you can still add it. Some of them, if it is needed at the early stage and you didn't say it, forget it. It doesn't matter. But there are some of the things that it may be important in the process. So you need to mention it. But there are ways to go about it. So for instance, much would depend on when the mediator discovers that an omission has been made. Generally, a missing impact can be added at any stage of the mediation, provided the mediator openly acknowledges that the oversight and emphasizes its normalcy in mediation. For example, I am sorry that I forgot to tell you in the beginning that it is a normal feature or phenomenon of mediation for the mediator to see the parties separately after a certain stage in the mediation. It will be too late to deal with the omission, and this might have little impact on the final product. So the fact that maybe you forgot something doesn't mean it will impact the final product, depending on the nature of it. Then we have third, the party statement. Now the party is being given the baton. So once they sign the consent to mediate and they agree. So once they sign the consent to mediate, are you ready to go on with the case? You sign and we go on. Are you ready? They said yes. Okay, once you are ready, so we move on. So the party statement. In most mediation, parties or their relative will be invited to make a statement early in the proceeding. Here, the mediator hands over to the parties and have the dominant role in the process room for the first time, but in a controlled and structured way. So the mediator hands the baton to them and ask them, as we heard, Elizabeth, you are the one who brought the matter here, so please tell me your side of the issue. So the purpose of the party statement are to allow each party to make their first contribution without interruption or confrontation, and to satisfy their needs to have their say and also be heard. So parties will have what? Their say and feel that they have been heard. Maybe they've been looking for the other party, they are not seeing them, they are not listening to them. By this time, they've been given opportunity and the other party have heard their plight. To provide information to the mediator about the parties concerned, particularly where the mediator has had no prior contact with the parties, as a basis for understanding the dispute and provide an agenda. So to provide a basis for the mediator to acknowledge what the parties have said so as to satisfy their need to be listened to and know that they have been heard. Then the last one, to provide an opportunity for each party to hear and to hear the other's presentation in the letter own words, and thereby understand what their current concerns are. So this one, the person speak in their own words, so that the other person will hear from the person's own mouth. Then the next one is to give the bigger picture. The party statement is used to let the other person know, oh, okay, this is what the person is talking about. And also it's so to give opportunity to assess credibility, sincerity, and other qualities of their principals and decision makers. So sometimes once this person speaks and the other person speaks, you begin to even question your own decision that you took. and also to confront each other with some aspect of others' case in order to create doubt about their own position and to achieve a day in court benefit for the parties who may wanted to go to court, and to allow venting and for cathartic benefits. So parties opening statement allow them, they can vent, they can speak, they can say all sorts of things, but allow them to vent for cathartic benefits. To give the mediator a sense of dynamics, who leads, who influences, and who is respected. Then focus on the party statement. Who does the parties talk to? So the mediator can invite the parties to focus on different factors in their statement, though the extent to which this guidance will affect what the parties actually say is unpredictable. That's mediator can attempt to make the focus and content of the party's opening statement. So for instance, if you are a mediator and you want fact-based, these are the questions that you ask. Tell me the history and facts in this case as you see them. As you see them. Tell me the history and facts in this case as you see them. So you want fact-based. Then right-based, tell me what your arguments and evidence are. That is right-based. Then we have positional way of what focus. It was tell me what you are here for. Tell me what you are here for. And what would you like to achieve in the mission, in the mediation? It is positional. That is their position that they have taken. So tell me what you are here today for. What would you like to achieve in the mediation? You let them know, they will tell you. Then, if depending on the nature of the issue, if they are legalistic too, these are the questions that you can ask. Tell me what the issues are between you today. Then we can have narrative, where narrative when you are doing narrative, you should know the people that you are doing narrative with. But sometimes some of the issues you have to go underneath so they can do narrative. Because sometimes if you ask somebody to narrate, they can talk for the whole day and you not see the head or the tail or the whichever of the things that they are talking about. So it is important for you to know. So if it is narrative, tell me what happened and what effect it has on you. So this is what I mean, that the person is going to explain everything to you. Then we have interest-based. Tell me what your concerns are today. That is interest-based. Tell me what your concerns are today. Then the next one, the problem solving. Tell me what decision needs to be made today. So what decision, or tell me what decision needs to be taken today. Then the person will talk. Then we have procedure-based. Tell me first how you think we should go about resolving the problem that we are dealing with. The person will now speak to it. So who speaks first? This is also another important thing but in normal cases, it's the person, the mediator decides who speaks first. And normally you give it to the person who brought the matter to speak. Then to whom are the parties addressed to? There are 2 points for directions of the party statement. As has already been indicated, party statement can be addressed to the mediator directly and not to the other party. And for instance, as you are doing mediation, as you are starting mediation, don't ask the parties to begin their statement by telling it to the other party. It will backfire, it won't work. So let them address everything to you. The other person is in the room, they will hear. That's the only secret. The other person is in the room. So the understanding is that while the other person is in the room and this person is narrating, the other person was here. So let them address it to you, the mediator. So this avoid heated or even hostile interaction. So if you ask the person to talk to each other right now, it may bring heated exchanges. Then on the other hand, where the parties are experienced in or comfortable with the mediation process and are professionals or are articulate, the mediator may encourage them to speak directly to each other at the opening stage. Encouraging direct session can give an opportunity for parties to reconnect with those with whom they have worked or had a relationship in the past and can encourage cooperation at an early stage of the mediation. But with this one, it is good you can do, but I do not encourage it. So I do not encourage this one. So mediator's role during the party statement. So what is your role? The mediator's main role during the party's presentation is to listen actively. That is active listening. How do you listen actively? Your body language, your gestures, how you conduct yourself, how you behave, how you let the people know whether or not you understand them or not. That okay, please a second. Okay, let's go on. So your gestures, your mannerism, the way this requires mediators to exercise good listening skills and display appropriate non-verbal language during the party statement. So if this person is talking and you are nodding, you must nod when the other person is talking. If you were looking at the person when the person is talking, you must look at the other person when the other party is also talking. So if the other party was talking and you were not writing, you should not write when the other party is also talking. They may also have to ask questions, but these should mainly be open questions. Some clarifying questions may be necessary where a party is unclear or ambiguous. But this is not the time for seeking detailed information, asking probing questions, or otherwise embarking on series of leading questions which either distract from the party telling their own story or make them defensive. When a speaker stops talking after only speaking very, very briefly, the mediator invites more information by asking an open-ended way. Is there anything else to add? Would you like to share further information with us? Would you like to go on? These are things that you ask for the party to also give more. Then, as suggested above, mediator intervention will also be required where a party statement is excessively long. I remember I asked somebody to share their side of the story, and they took more than 1 hour. They didn't care about the time you have given them. They were just talking and talking and talking and talking and talking. And in fact, I was tired that day. I suffered. So these are some of the things. So you need to intervene. Like, yes, thank you. Please, can you tell me briefly about the issue where we can have enough time? Later we can go through. Yes, we'll listen to the rest of it, but what brought this matter? Can you share this with me? So that if not, some of them will narrate and narrate and narrate and narrate, and it will become difficult. So excessively long or descent into unnecessary detail for this stage of the process. Here, the mediator should restate the purpose of the party statement as being to provide only an overview of the problem and reassure the speaker that there will be a later opportunity to go into details. Where there is repetition of a particular fact or theme, the mediator will need to acknowledge the point being made and even write it down to cure the broken record symptom. Another role for the mediator during the party statement is that of the note taker. So depending on which stage, normally at the first stage, you don't take notes. You wait for him to finish, then you summarize and write the points down. So most mediators take only brief notes, usually words or phrase to report key concern and interest, common grounds, and areas of potential agreement and perspective concession. It is difficult to practice good listening and take comprehensive note at the same time, though there can be a division of this labor between mediators. A common form of note taking is to follow the mediator devise a page with vertical lines. So you have a blank sheet, vertical line part A, part B. So whatever you put their points here, you put this one points here. So as the mediator records words or phrases under the appropriate column, he or she can connect concerns common to both parties with a line or a number asterisk to assist with the later development of the agenda. Request for reply. So sometimes the moment the party finished talking and the second person has also finished talking, you must let them know that there is no need for reply, and that you going forward, you talk about some of the issues and they will have opportunity to bring in more information. So the first speaker or their advisor might also ask for a right of reply after listening to the second speaker. In most circumstances, this should be denied for the same reason that the second speaker was asked not to respond to the statement of the first speaker. A mediation is not a debate or a courtroom combat. A reply is likely to involve justification, denial, excuse, and also lead to an adversarial confrontation too early in the mediation or in the piece. A summary of the party statement is more appropriate development at this stage. So mediators, summary of the party statement. So parties are talking. Once the parties finish talking, the mediator typically thank each party for listening to the presentation and for each party's openness and frankness. Some, but not all, mediators summarize the party statement, normally after both parties have paid. But once you are starting, I encourage that once one party finish talking, yes, thank the person. Thank you. I know this must have been a difficult situation for you, but listening to you, I recognize that you, or if I understand you perfectly, you mean A, B, C, D, and you put them down. So to summarize the first statement that any advice has been made would be sometimes to devote excessive attention to the party and to leave the other in the post. Sometimes maybe summarizing this one first and asking clarifying questions before you go to the other person, maybe sometimes the other person may feel left out, but I encourage that once you are starting, you do that. The statement several times function to reassure the parties that they have been heard correctly as regard to the content of what has been said. So it is important to do that. Provide some acknowledgement, validation of the emotional side of the party statement, enable the mediator to check accuracy of the understanding of what has been said, and provide feedback if they have got things wrong, and require each party to hear what the other has said for a second time, and also allow a party to add to their statement when they realize from what they realize from the summary that is indeficient. So there are different summaries that you can give, types of summary. There are actual summaries. Actual summary means that some of the parties actually words are used so that they hear from the mediator's mouth that the same terms they have used themselves. Early words and phrases in particular are restated in their original form. So if I understand you correctly, you mentioned A, B, C, D. So you mentioned the same thing that he said as he said it, that the person will confirm. That's the actual summary. Then reframe. This one is normally used when you realize that parties use words that are unkind among themselves, then you can reframe. So the mediator reframes the party statement so as to shift to remove the stench from any comment and focus on the future. In this method, the mediator avoids the actual words of the parties and provides a sanitized summary. So then we have cross summary. The mediator asks each side to summarize what they have heard from the other side in order for them to walk in other person's shoes. So sometimes this one, it can work in some cases, but it cannot work in some cases. So we have to be careful depending on the people. So actual summary gives the parties the experience of being heard. In actual summary, the mediator should use the second person and report speech. So by the way of summary, you told us that. So that is how we do it. So this distance the mediator from the statement which are hostile to the other part. Therefore, the mediator should also not use the hostile word. Cross summary involves several risks and for limited potential, so you should be careful. Then we talk about caucusing. I think we have mentioned it before. Caucus is a private meeting between the mediator and just one of the parties that is held out of the earshot of the other side. In some mediation, there are no caucus at all, whilst in other mediation, mediator may caucus with each other once or multiple times, depending on the situation. It's always up to the parties to decide if they want to use private meetings. So it's the parties that decide. So caucusing is not compulsory. The mediator can decide to caucus or decide not to caucus. So that can also work. There are issues that you don't need to do any caucusing, but there are issues that you may need to caucus. Caucusing can be seen as a carefully considered strategic intervention. That's about Chipropo, apart family mediation news center, that's an association for conflict resolution. Some mediators feel that caucusing gives the mediator too much power to interrupt messages and defines issues and engineer a result. That these acts should be left to the parties themselves. These mediators see themselves as facilitators with the real power held by the parties. Caucus may be especially appropriate anytime in the mediator's intervention runs the risk of creating an appearance of uncertainty, weakness, or embarrassment in one or more parties. Most mediators will try to avoid having a party lose face in front of the other party or the parties. Reason for caucusing is to create a productive pause in the process, so relief from tension. Sometimes if you feel that there are impasses and the parties are not able to move forward with the issue, if the parties are unable to move forward with the matter, the caucusing helps to create a productive pause. And then it engage in a mediative reference what-if processes, permit party movement without losing face, and offer negotiation advice. So have a look at it from this point. You are not saying go and advise the person on what to do. For instance, if you look at the video you watch, the person find out from them, are you able to share this information when we come back to the plenary session? So these are negotiating advice. Then he said, yes, I can share this, I can say this, yes. Assess alternatives to negotiated settlement, test whether a party proposal are realistic, act as a sounding board, work to develop settlement proposal as a means of gathering information that will not otherwise come out. So the caucusing is used for that. Then confidentiality in caucusing. Caucusing to, if the mediator chooses to caucus, it is critical that the mediator and the parties should reach clear agreement as to the confidentiality of the caucus meeting. So if the mediator must find out from the party, would you want me to, is there any information that you want me to share with the other party, or you don't want me to share anything with the party? So that you going to meet the second part, one person will not feel that you are going to share their information with the other party. So let them know that as they have met you and they are having that discussion, whatever you are discussing with them remains between the two of you, and that you will not share unless they ask you to share something with the other party. So this can be done in the agreement to mediate or less formally during the mediation itself. So better practice is to clarify agreement as to the degree of confidentiality of caucus session and any exception to such confidentiality in writing. Mediators and parties will typically take one or two approaches. Everything said in the caucusing is confidential, or everything said in the caucusing can be shared, except party especially instruct. Right. Then mediator's role. What is your role after the caucusing as a mediator? So the mediation process is going on. After the caucusing, what is your role? The mediator is advised to generally caucus with all the parties if he or she caucus with any party. The purpose of this is to maintain balance. There may be situation where this is not necessary, such where one party wants to specifically discuss a settlement option in the private and the other party does not feel that they need to do that. List all the things you believe we may be able to easily agree on. Come up with at least two settlement arrangements that will work for you. Then what would you be willing to give the other side to get what you want, and what would you need to receive from the other side to agree with what you want? So all these things you, the mediator, will help them to do. Then when you come back and do joint processes, and as you saw in the video, and you continue. So all the things that we are discussing have been put together as this. Preparation. So the preparation part, you the mediator and the parties. So the mediator parties, so mediator statement, parties, you prepare the parties. So that's where your mediator, you give your opening statement to the parties. So you establish a protocol that we call ghost protocol. So ghost protocol simply means be gentle, be honest, be open, be sincere, or the sincere can also be specific. And the last T is talk. So when you see this ghost, it's not the ghost that you know. It's described as people are supposed to be gentle, they're supposed to be specific, and they're supposed to be honest, open, and be able to talk and be able to be specific or sincere. And then you establish confidentiality at the preparation stage. You confirm authority, you confirm time, you describe the role for the mediator and the parties and what is going to happen in the mediation setting. Then you transition. Are you ready to proceed? Then you move on. So after you have prepared the parties, you have to remember that you, the mediator, you must prepare yourself to be dealing with issues. So this is where you wear your active listening skills. So to receive the information and be able to conduct yourself well. So active with listening, to pay attention to each party's perspective, demonstrating empathy and understanding as a mediator. Once they are going to talk, you must be able to demonstrate that. Then open-ended question, encourage parties to share their thoughts and feelings, fostering deeper exploration of the understanding or the underlying issue. So the mediator, you must demonstrate this. So once you have explained everything to them, and you, the mediator, know that you have to demonstrate this once you're going to hear information, then you go to the storytelling, or what you call the uncover stage. So ask, what are you here to resolve today? So this is more interest-based question. What are you here to resolve today? What are you here to resolve today? Can you share your side of the story with us? So listen, look at the speaker. At this point, it is encouraged that do not take note as a mediator. So listen, let the party feel that you are listening. They are being heard. So listen, acknowledge each speaker. Thank you. So once they have acknowledged, they finish talking, acknowledge, thank you. Reframe to neutralize a word or create title for the conversation. So you frame and you create title for the conversation, then confirm and write circumstances on chat. So you have summarized to each party. After that, you compare the two summaries. You get teams to make agenda. So you know your agenda. So now, once you have gotten your agenda, you move on to the learning stage. So the sequence of the circumstances, parties now talk to each other. So looking at this agenda, starting with no particular order, looking at this, what do you think can be done with this point that the two of you have raised? Then the parties will now be talking. So share with him, share with her, tell him, tell her, tell this. Then they will be sharing. Remind parties at this stage, sometimes it can be heated. So you remind the parties of the GHOST protocol as you discuss from the preparation stage. Invite the parties to talk to each other. Tell each other what is important to you. Listen. Look at the listener. So now the attention has moved to what? Look at the listener. Wait, and now you can take notes. Trust in the process. Wait, let them talk. Don't just be shouting, hey, don't do that, don't shout. Don't. Just relax. Trust in the process. Let them talk. Support conciliatory gesture when left unnoticed by the other party. Confirm prospect on chats and write on the chat. So from your discussion, I realize that you are coming out with some certain options on the various points to resolve the matter. Kofi Mensah or Jessica, can you tell me your options looking at this? And they will tell you 1, 2, 3, 4. Akwasi, can you also tell me your options, this and this and that? At the end of the day, you look at where options that they have given, you realize that some people may give options that the other person has also given, and you may be having similarities, and you deal with the ones that they have not. Then you search for possibilities. Your opportunity now is to generate options that will meet your unique and common needs. I'll capture your ideas here on the chat. What can you do to resolve this? Looking at this, and they will tell you. At this stage, alternative possible solutions must be generated. And this is where the mediator to you starts writing something down as part of the solution. The process works best when there is an idea to work with. Write down all the options, analyze each of them with the parties. Then explain what do you agree to do. Now, if they have underlying statement or they have agreed to do something, you find out now, tell me, based on the discussion you had so far, what have you agreed to do? They will say, okay, we have agreed to do ABC, you have agreed to do this, you have agreed to do that. What do you like the plan to say? So if there is money involved and they have agreed that this is the amount involved, how should the payment be done? What should be the plan? So I can pay in installment with 10 months. Someone will say, no, 10 months is too much. So you are looking at the plans back and forth, do this. How am I going to receive the money? I'll post it or I'll send it to your bank account. I'll send it. Who is supposed to check? All these things are discussed at this stage. Confirm the plan by reading it out to them. Confirm commitment to the plan. And now, after you have confirmed this, close it. So you review the process, the purpose, tear up the notes that you took. So as a mediator, if you keep notes like this one, like I've taken, you tear them up, you tear confirm confidentiality that no notes is being kept. The only thing you keep during the mediation is the request form that the parties use to request for the if the parties requested for a case, so the request form you keep. If there were any evidence attached to the request form, you keep it as well. Then after that, if there is an outcome, you keep it. So these are the documents that you keep. The request form, if they had any document attached to it, then the consent to mediate, then the outcome. These are the documents you keep. Any notes that you took during the mediation, you destroy. The parties also destroy their own. Confirm feasibility and authority to implement the plan and treat parties to use the protocol techniques to deal with one another and circumstances as and when they may arise. So on that note, thank you so much. Any question up to this point? Any question, please? Any clarification? Okay, those who are online, you can put your videos on. Today we have not taken a picture. Let's take some pictures. I hope you are learning. Okay, so I want to hear you put in the chat what have you learned so far for this session, from morning to this time. What have you learned so far? Put in the chat. Plenty can mean anything.
I'm organizing my head.
Any chat.
Please travel from. Prof Blue.
Okay, I'm taking another one. Okay, so let's go. Say cheese.
Cheese.
Okay, I'm taking the second page. Okay, all right, so we have another presentation, then from there we'll move into role play. That presentation, I'm going to do it with Lawyer Kezia.
Hey, how? Without any notice.
I think Lawyer Siwesi was supposed to do it. I think she has been stuck in certain activity and she's not here. So I'm going to do it with you. For this one, everyone knows it. I'm going to project it. We are all going to discuss it's communication, mediation, and emotional intelligence.
Oh, okay. Just a discussion.
Yes, so we are all going to discuss.
This is deep.
Did someone say something?
Yes. I said the topic is very deep.
Oh, okay. I see. Okay, so this is it. This is the presentation. She prepared a presentation and sent it. Hoping that she'll be here, but I think she's stuck somewhere. So let's go through together. So this is by Suesi Yaji Ondo. She's a lawyer in Nigeria. She's based in Abuja. So she's a lawyer called to the Nigerian Bar, dispute resolution specialist and ADR practitioner, a certified data protection officer, certified management trainer, chartered manager, human resource consultant. So plenty she has, and also founder Prime SPG Legal Consult. So I was hoping, but she may join us in the course of the training, maybe not today. Okay. So what she has here is that if there is no communication, then there is no respect. If there is no respect, then there is no caring. If there is no caring, then there is no understanding. If there is no understanding, then there is no compassion. If there is no compassion, then there is no empathy. Then there is conflict because there is no communication. This is by Shannon L. Elder. Do you agree with this statement? This one, I said that it's not my presentation. We are all going to discuss. Do you agree with this presentation, this assertion by Shannon L. Elder?
Yeah.
Okay, who said yeah? Share your thoughts on it for us.
Joy.
Yeah. I subscribe or agree with Shannon Alder that when there's no communication has to do with when you engage, with in discussion with somebody, when there's an issue, you create an atmosphere, to communicate with that person. It shows you respect that person. You don't, because since God creates us all as individuals differently, we don't see things the same way. So when there's a conflict or a dispute, if you don't hear from the other person, you don't even allow the other person to talk, that means you don't respect that person's opinion. So if there's no communication, there's no respect. And also respect, also you see all these things, they are interwoven together. When there's no respect, there's no caring. You don't look at the other person's side of the coin. So the issue of care comes in there. And then when you don't care, it means you don't even look at that person's position. Your position may be different from that person's position. So that means you're not understanding where the other person is coming from. The other person may come from a different background from you and does not see something the same way you see. So when there's no caring, that means you don't really understand the other person. And also understanding also has to do with compassion. For you to even look at the other person's side of the coin, it's you have to have a kind of the compassion. You put that and empathy at the same time. You put yourself in that person's situation. So when all these things are absent, then a conflict arises. Yeah.
Okay.
So
Thank you.
that's what you're saying is a correct statement to make. Thank you.
Okay, thank you. Great. Engineer, like I said, you'll be the last, then you continue.
Yeah, okay, thank you for the opportunity. For me, I don't agree with any of the statements. Statement number one, if there is no communication, then there is no respect. I don't agree with that, because the fact that you are not communicating does not mean that you don't respect somebody. An issue may have arisen, but it doesn't mean that you don't respect the person. Two, if there is no respect, then there is no caring. That one too, I don't see how caring and respect go together. Three, if there is no caring, then there is no understanding. It's rather if there is no communication, there will be no understanding, not the matter of the caring. Four, if there is no understanding, then there is no compassion. That one too, I don't see how, because there is no understanding between you, and that may generate a dispute, and therefore there is no, that one too, I don't agree. If there is no compassion, then there is no empathy. And that is completely opposite. You may have empathy for the person's situation, but it doesn't mean that you must have compassion. Then number five, then there is conflict because there is no communication. After that, if there is no communication, it may lead to a conflict, because the communication will have explained the circumstances of each other. So that is my position. Generally, I do not agree with the statements. Thank you.
Okay, thank you, Engineer. Like you take over, so I'll be scrolling for you.
Hey, my friend, Jaisa. Okay, so this is all I have to add to what my sister Joy has shared. Communication is the bedrock of every dispute resolution mechanism, or every relationship, communication is the bedrock of same. So without communication, the likelihood of misunderstanding and conflict is very, very high. So I partly agree with what Shannon says. I think that we should communicate, because if you don't communicate to your friend, your partner, your business colleague, your investment advisor, all the relationships that we have, if we do not communicate, they would not know how to even serve us better. Thank you very much. On that note, I think we are doing this together. Please don't run away.
Oh, good.
Okay, so go on.
Okay. So, ladies and gentlemen, I've been put on the spot, so I have to make that disclaimer. Let me try and put on my video. Maybe I'll put up my video so that the boss video will be there. Okay, so we are saying that we need emotional intelligence as ADR practitioners, especially as mediators. You know, as a mediator, we have already learned all the fundamental issues about mediation, who we are, what we stand for, how we are supposed to listen with empathy. So we must actually ask God to change our emotions, to become much more empathetic, highly intelligent as we deal with the issues. We will not be able to help people negotiate interest-based outcomes if we do not work on ourselves when it comes to emotional intelligence. Because there are some people who come before you, they will come and test you, but you have to be very careful. You don't have to show emotion, you don't have to show where your position lies. You don't even have to tell them what the law says at the beginning. Can we proceed?
Yeah.
So this concept of communication and mediation is as follows. It means different things to different people, okay? So exchanging of information, you could speak, you could write. Some people are very good writers, but they don't know how to speak. In the course of you mediating the matter, you must be able to look at the parties critically and make a decision as to how you would want to proceed. The motive of the communication, how the communication is carried out, the words, the gestures. You know, one of the ground rules in the mediation room is to tell the people not to raise their voice, not to call names, not to behave in a certain way. But you know that as a mediator, you may meet people who are hell-bent on disobeying the ground rules. How do you intercept and guide the conversation? You have to be very strong. You have to be very careful. You must develop your own communication skills gradually. It doesn't come in one day. We are all work in progress. Next slide, please. So why do we communicate? We communicate to express ourselves. We communicate to make demands. We communicate to get benefits from the other person. We communicate to let the other person know and understand how we feel, to express ourselves, our thoughts, our ideas, our emotions. But then, again, we must make sure that our communication does not offend the other party. We don't go overboard because we are expressing ourselves. That is a very important ground rule for every mediator. Let's proceed. So what are the elements of communication? As a mediator, you must blend the whole chart, but make sure that you are on top of the issues. You are going to do spoken words. You are going to make sure you choose the right tone. Your body language must be such that you are like a judge. When you enter into the courtroom of every good judge, they don't show you where they will go. They will go there. That is how we are supposed to posture. So your emotions, your facial expression, everything must be highly neutral. You don't laugh, you don't giggle, you don't give room for the other party to laugh at the other party, call them names. No, you don't. You quickly have to make sure people apologize when they go overboard. Your voice should never go at a certain level even when you're upset. It shouldn't show that you're upset. Let's go on. Okay, so what are the variables? Sender of the communication, the person who writes or the person who speaks. The person who receives is the receiver, okay? Or the medium through which we send the message. We write letters, we write memos, we talk, we send WhatsApp messages. These days, even when we are doing financial transactions, you can just respond by saying, I, so and so, have received the sum of 2,000 as consultation fee from you for a case I'm coming to do for you. WhatsApp. Feedback. I'm going to receive the feedback. Still by communicating one way or the other. I wrote a warning letter to somebody and I gave 7 days. That if the person does not respond in 7 days, I'll sue. So yesterday I got a frantic call from the lawyer on the other side. Hey, I use so and so. I want to make sure I'm reaching out. I want to come and explain my side of the story to you. That is feedback. So communication basically goes through different processes depending on how we want to deal with it. If we write, it goes through the mail, then goes to the other person. If we speak, like I'm speaking to you right now, my voice is going through the system, it's coming to you as if I'm real time with you in your room. Let's proceed. So communication can be verbal, it can also be non-verbal. Sometimes the non-verbal communications are louder than the verbal communications. Some people, the kind of things that they would use their body to say, I mean, it will be more serious than if they verbalize it. So we have to be very careful, okay? Verbal communication is what we are doing right now. We are speaking non-verbal. When we write, we do other things. So some of it is gestures, facial expressions, the way we chuckle, the way we look at the person. Sometimes somebody is coming into your office, the way you look at them from the top of their head to the sole of their feet. That is communication. And as ADR practitioners, for me, the person who trained me 21 years ago, he taught us that we must make sure that even our demeanor, our composure, our way of doing things should be highly neutral. Okay, to the extent that we cannot even show our political leanings. That is how much we were trained in that time. I don't know what Isaac would say in our current dispensation. So non-verbal communication is very, very important because as a mediator, you may sit in the room and the people will read your non-verbal communication and that will be the end of the discussion. They will not settle. Let it not be part of what we do. Let's proceed. This one is smaller. My glasses are not here.
Okay, then let me take this one. Let me take this one. Okay, so this one is talking about non-verbal signals or body languages that as a mediator you must also pay attention to. So we speak not only by our words, but also by our actions. So people speak, as Kezia was saying, that some people, what they can do with their body speaks louder than what they would have said with their mouth. So action, they say, speak louder than words. And we want you to understand that. Maybe sometimes you could see the person is saying something, but acting differently. So that should give you maybe an idea as a mediator to probe further, to ask more questions. Because the thing is, communication, as we say, is information from the sender to the receiver as intended. So if the person receiving the information has not received the information as you intend to send that information, then it means that there hasn't been any effective, although there have been a communication, but there hasn't been an effective communication. So it is important for us to understand this principle. So example and possible meanings. So we're touched with a single finger, indicate call for attention. So maybe somebody touch you with a single finger, which means that the person is calling for an attention. or somebody may be shaking with both hands, shows warm, or maybe the person has folded their arms and they are shaking like this. If you are in a cold room with the person and they have folded their two hands and you see them shaking, it means that the person is feeling cold. So you don't need, you can find out, is the room too cold for you? Do we reduce the air condition for you? Then you can assess that person so that at the end of the day, it won't be like I was feeling too cold and I couldn't know what to do, just to accept whatever that they were discussing so that I can leave the room. So it is very important that when you observe those things, you as the mediator will assist the parties. Then a frown, shaking of head implies rejection. So some of them, shaking of head and nodding are not the same. So you see somebody nodding, it means that the person is in agreement. So a nod indicates acceptance. But if you see the frown, person has frowned and the person is shaking the head, you know that there is some level of rejection. Or sometimes even somebody may be shaking their head and they will give some little smile. It points to certain direction and you must take heed to that. Then arm around the shoulder indicate friendship or the companionship. Then arm around the waist implies intimacy. Then palm on the laps, say I care, I have affection for you, those things. So these are some of the signs you should also know. So communication skills in mediation. One.
Okay. The ones that I can do, let me do them, because I can do this one which is bigger. If it is smaller, then you do. Is that okay?
Okay, please go ahead.
So communication in mediation includes active listening. This is where we have to put off our phones and give instructions to the people to also put off their phones. Listening with empathy. Show them that you are concerned with what they are saying. Guard your body language. Asking the right questions. That is where the Holy Spirit must help those who are believers. Because your one question may throw everything upside down. And I think that when we do the role play, there's a lot of learning that will come out for us to know. None of us is perfect. We learn, we continue to learn, we make the mistakes, we keep learning. Okay? If you don't know which question to ask as a mediator, just keep quiet and keep listening. But try to stop them if they are going overboard or going outside of the room. Let's proceed.
Okay, let me continue from here. So active listening, that is non-verbal. So this involves the application of softened formulas. Softened formulas. So some of the softened formulas can be smiles. A smile say, I am glad to see you. You make me happy. Open posture. This is inviting and also encouraging free discussion. Then we have F, which is forward lean. Physical forward movement indicates rapt attention. Then we have T, touch. An appropriate touch say, I am with you. Please go on. Then I, eye contact. E, eye contact shows attention and interest in what is being said. Then nod indicates N, nod indicates acceptance and I'm following. Please speak on. So you have to take note of these small actions, non-verbal actions when you are in mediation as a mediator. Because sometimes a person may accuse the mediator that the mediator did something or showed something which the mediator is considered as being biased. So it is important for you to make sure that if you are doing this, if you were having an eye contact with the other party when they were talking, have the same eye contact with the other party so that you'll be on the same page with them. Active listening techniques.
Hold on. To add to what Isaac just said, do not look like you are on the side of one person. You see, when I teach some of these courses, I tell my students that, let's say you are dealing with a child custody or child maintenance matter. Then straight away, you start making blanket statements. As for children, it is only their mothers that will be given custody if you go to court, or the children must be with their mother. or the father must pay all the bills. These things are traditional things. We have moved. We have left. Some fathers are better custody maintaining persons than some mothers. Some mothers too give money more than some fathers, depending on the economic situations. So watch carefully how you jump about and take a position. Sometimes when the person comes with a domestic violence case, I mean, we have always been telling us that we should temper and be very careful. You see, if you don't listen to the other side, you may take a position. And here we are making a decision, the parties themselves are making their decision. So if you show us a little sign that you are on this person's side, just a little, they may not settle, not because they didn't want to settle, but because they feel that you have taken a position.
Okay, so thank you, Lakiza. Active listening techniques. So what will make the people know that you are listening to them and you understand what they are saying? So for instance, first, summarizing the mediators outlines the main points made by the speaker. So the speaker has finished speaking. If I heard you correctly, you mean this. Sometimes using their own words. I heard you saying this. Correct me if I'm wrong. You meant this. You mean to say this. It makes the person feel that, oh, okay, the mediator understands me. They are listening to me. They share what I'm going through. Or sometimes reflecting. Mediator confirmed they have heard and understood the feeling expressed by the speaker. I understand this must have been a difficult situation for the two of you, or for the both of you, or for you. I share your pain. So these things it makes the people feel that yes, the person understands. You have a feeling, you are reflecting of what they have shared with you. Then reframing, used by mediator to help the parties to move from position to interest. Acknowledging then in this mediator verbally recognize what the speaker has said without agreeing or disagreeing. So you, the mediator, you are not there to disagree or disagree. You are there to bring out what they want to share. Then deferring, this mediator postpone the discussion until later. So when you realize that, oh, the emotions are high, you can decide to postpone the discussion. You can decide to let them take a break. You can decide to caucus. The mediator should be able to adapt to what is happening in the moment. You move with what is happening. Then encourage the parties if they feel upset. Then restating in mediation reassures the party statement he heard from the speaker. Questioning, use open-ended question to clarify from the parties and also setting the agenda for the discussion and help to continue the communication. Because in the mediation, you, the mediator, make sure that the parties are communication. Your tool to work with the parties is how to communicate with them. So you bring out things that will help the parties to talk. Because if you are not able to bring out points that the parties have raised so that you can create agenda for it, you meet a deadlock because you will not have issues to talk about. Then a synergy between effective communication and emotional intelligence. So effective communication is facilitated by emotional intelligence. So how people receive things, perceive information, and they react to it. So emotional intelligence, which is in expressing oneself clearly and sensitivities. So it involves not only articulating thoughts and feelings in non-confrontational manner, but also actively listening to others. This balanced communication fosters mutual respect and ensure that all parties feel heard and valued. So emotional intelligence definition. Emotional intelligence, that is EI, refers to the ability to perceive, control, and evaluate emotions. So your ability to receive, perceive, and control and evaluate your emotion. There are instances where people The moment they hear information, then they begin to react and take certain decisions which later they will regret. So emotional intelligence can be learned and strengthened, even taught. It is an inborn characteristic. So something that you develop, you nurture it. Everyone has it. Because you maybe sometimes you react to certain things, so you must nurture the way you react to certain things. So Dr. Daniel Coleman coined the term emotional quotient and likened it to the traditional intelligence known as IQ. So emotional intelligence is about how smart we are with human connection and how smart we manage ourselves and our relationship. So the more emotionally intelligent a person is, the more effective they will be in communication. So when persons are able to, or they have ability to perceive, so you know the situation of the other side, you are able to control yourself to know how you can evaluate the emotions and being able to speak and do things that will help in the discussions rather than just opening your mouth and saying anything. So from Dr. Coleman, called the term emotional.
Somebody says, Kezia says she can handle slides with bigger fonts. Hey, you want my voice? You people.
Emotional quotient and liken it to the international intelligence. Can you see this one? I thought you said this ones are small. That is why.
Okay, so let me try. Since somebody is protesting. Okay, Dr. Daniel Coleman coined the term emotional quotient. He likens it to traditional intelligence known as IQ. Emotional intelligence is about how smart we are with our human connection and how smart we manage ourselves and our relationships. The more emotionally intelligent we are, the more effective we'll be on every single level. It's true. In fact, very emotionally intelligent people, you can't read them. Hey, you can sit on a panel with the person. You can't read their position, but they will take a decision, you'll be shocked. I want to get there. That's for me there. Yeah, I show my mind people. Let's proceed. Let's proceed. Okay, so Isaac, the next slide. To understand emotional intelligence refers to the ability to, we've done this one already, the ability to perceive, understand, manage, and use emotions effectively in oneself and on others. It plays a critical role in the success of mediation. You see, because in the mediation room, you are not supposed to show how you feel, what you think, what your position will be, how your decision will be if you were a judge. No, because mind you, some of us have our colleagues as high court judges. So if we wanted to go into that system, we could be there. But you see that as an ADR person, and you are not supposed to show anything. You're supposed to look very correct, okay? It has 4 major components. Number 1. Isaac, please move. Number 1, you have to be self-aware. If you are like some of us, where we say our mind easily, when you enter mediation, don't say your mind. Put that one under lock and key, okay? You learn gradually not to say your mind. Then you strengthen your emotions and make sure the weakness of saying your mind, you put it somewhere. In conflict situations, self-awareness allows us to ensure that everything that triggers us, we keep it somewhere else, okay? Look at the things that trigger you before you enter the room as a mediator and make sure you lock it aside. The fight you had with your partner before you left the house, don't bring it to the room. So that when you see a certain woman's face, facing a certain man out, you say, this is what they do. Daughters of Eve, no. Being attuned to our own emotional states can avoid us letting our emotions on other people, okay? We have to be very careful. Otherwise, any small trigger, the person will not allow us to settle their dispute. Number 2, self-regulation. We have to manage our own emotions. We have to be constructive in the manner in which we deal with ourselves under stress or provocation. So you must know yourself, okay? Know the things that would worry you and work on yourself before you start the work. And then gradually, as you work, you have to be evaluating your own life by peer review and things like that. So it includes impulsive reactions, staying calm, because some of the parties that come before you come and test you, they will behave some way. You have to keep your composure, okay? Effective self-regulation helps individuals to approach conflict with a level-headed perspective, reducing likelihood of a reactive behavior. A mediator should never, ever, even when they are insulting you, don't react. Let's move on. So social awareness is the ability to recognize and understand the emotions and perspectives of others. We have already learned that we all come from different backgrounds, different homes, different training. So we will be reacting and doing things differently. How are we supposed to respond to that as mediators? We must be careful. We use empathy, we use understanding, and try what we can try, okay? By accurately perceiving others' emotional states, individuals can respond in ways that acknowledge their concerns and foster mutual understanding. Let's move on. So relationship management encompasses the skill needed to build and maintain healthy relationships, including effective communication, conflict resolution. In conflict situations, strong relationship management skills enables individuals to navigate disagreements constructively and negotiate solutions that maintain positive interaction, even in the face of challenges. Okay, so you don't give up because the people sitting before you are very difficult. Some people, if you pass here, they'll pass the other side. If you do this, they'll do that. Everything we are teaching you, you use it, but they will still try to make you small. Okay, so you have to just break, adjourn the case, adjourn, or use caucus method, okay, or go for a break and then come back, okay. Emotional intelligence. Sometimes some of my friends, they will call me and say, I'm doing a certain case. What in the caucus, what advice do you think I should give? Then we give them what they should go and ask, what they should tell the person and things like that. So you can do that. If you become overwhelmed, you need to find a way around it. But don't shout at the parties, okay? Good. Emotional intelligence is vital in recognizing and understanding emotions of yourself during conflicts. When people sit before you, they are in conflict. They are not people. They will add you to the conflict. Awareness of your emotions is so important, okay? And then trying to look at the other party too. Understanding other emotions also will help you to empathize and facilitate the communication and do a better work, okay? Ability of mediators to understand not just their emotions, but that of the parties is very, very helpful. So sometimes you can start the conversation by telling the parties to introduce themselves. Sometimes in the introduction, you're able to pick up a few things that will help you later, when they start misbehaving. Okay, let's proceed. Yes, how many slides more? Oh, we are done. So the ability of the mediators to understand not just their own emotions, but that of parties is so important. It will help you tick the box and guide parties towards achieving optimal results. So high emotional intelligence in mediators is so important. You do active listening, you empathize, you self-regulate, you de-escalate, you uncover underlying interests. You see, as you get to understand a little bit of the background of people, understand a little bit of their temperaments, as you ask questions, you'll be able to tell how you can guide them into an interest-based resolution. Focus on emotional intelligence and rational and be rational mediators and turn from potential barriers into bridges, improving overall effectiveness of the mediation process. On that note, Isaac and I are grateful for the opportunity. Thank you, Mr. President.
Okay, thank you so much. At this stage, thank you for not announced presentation, but you did it. Gemma, your microphone is on. Do you want to say something?
Yeah,
Is the name? Is it? Yes. Do you want to say something?
I'm hearing you.
Okay. Okay. All right. How is Ethiopia?
It's fine, fine.
Okay. Great. So I'm opening a room for all of you. You have been automatically been put in a room. So room 1 up to I think 4. Room 1 up to 4. When you go, what is what I want you to do. As having been taught about mediation today and the mediation process, I want you to prepare as a group within 20 minutes, prepare a checklist that you're going to use to run your mediation process. So when you receive a case and you are sitting as the mediator, what are you going to say from the beginning? At what point, at this point, you're preparing a checklist. The checklist will be like you are doing the opening statement. So prepare a checklist as a group. Then within 20 minutes, you come back. So I'm opening the rooms. I hope you have heard the instructions. Hello, can you hear me? Let me see in the chat whether you've heard the instruction. I'm putting you in a room for 20 minutes. You are preparing a checklist. Okay, good. Okay, so we are all going. So please join your groups. Please, those who are here, click on your room and join. So this means that some of you are just online. If you are online, click on your room and join.
Refusing to join. Oh.
Please, if you are using a phone, on top of the right corner, you will see a button there. Click on it, you can join. You see the join. You see the rooms, and you know the one that you are supposed to join.
Hi, Isaac. How are you? Hello.
Gemma, your hand is up. Do you have any issue? Hello, Gemma, by you. Your hand is up. Do you have any issue? Okay, welcome back. How's your interactions? Now you've got to know yourselves as well. So this was also a network opportunity for all of you to know yourselves, your group members, know yourself from other countries.
Hello.
So how was the discussion? How was it? Yeah, Gemma, you want to say something?
Yes. Okay.
Yes.
Today's presentation is very well. I am listening to you very well. It's excellent presentation. Can I get this copy, hard copy or something?
So the policy is that for those who request for the certificate, the materials will be added to the certificate for them. So at the end of the day, a form will be sent on your platform for you to fill. Those who request for the certificate, you can, all the materials will be shared with you.
Okay, thank you. Thank you very much.
Okay. So I want to hear from you, group one. What did you discuss? Room one. Room one. Oh, room one, I can mention your name, so but I thought maybe you don't want to mention your name. Room one. Abdullah Seydu, Sam, Nafisa, Lydia, where are you? Hello, room 1. Oh, room 1, no one is here. Okay, Nafisa, yes, we want to hear you. What did you
Yes,
discuss? Yes.
Isaac, I tried to communicate in the room 1, but nobody responded, so I just stay silent there.
Oh, so no one spoke in room 1.
Yes.
That is very sad to hear.
Sorry about that.
Wow. Wow. Okay, room 2.
Yeah, room 2. I think even though it took time for all of us to get together, we were just 4 people in that group, that room. And these are the issues we have tabled. We indicated that venue is very, very important. So first and foremost, we try to identify a venue that would be a befitting venue. You know, venue can actually, somebody first impression, venue can just trigger something that will let the person not to open up. So an acceptable venue is very, very key. Then 2, I mean, before even the venue, you need to know the background of all those you are going to your clients. Because if you don't know their background, you may not be able to know their background. And there you are, you introduce yourself very clearly. Give them your first meeting is very, very important. They may not be able to open up for you. So you use that platform, that first meeting, to really introduce yourself properly for them to, so that you agree on some, you let ground rules in relation to, because everybody, they are here, they are there, we are meeting because of an issue. So you design the rules in such a way that it will help us tease out the issues that will help us resolve the issue. So you set up ground rules. Then you assure them that everything that is going to be discussed here will actually be confidential. Nothing will go out. You give them that assurances through your constant eye contact with them, and then your body language will actually let them actually build that trust in you. And then you also motivate them. The first meeting may be so difficult for some of them to open up, but your interactions will be able to motivate them to speak to the issues. As we saw in the video, we realized that when you look at the facial appearances of the 2, you realize that they were tensed up. Nobody was actually looking at their body language. It shows that they were not too sure this will actually be resolved. But along the line, you see that they open up, especially when they included the one-on-one interviews. New things have been able to come up. And then you have an open, your question should be open-ended, so that at least it will let them be able to fit in properly, to provide the necessary information that you need to work with. And constantly, you have to let them, assure them of neutrality. You have to let them know that constantly, you assure them that neutrality is key. And then that is, as in the process, you constantly remind them how neutral you are. And then you maintain eye contact, because body language speaks a lot. Look straight into their eyes when they are providing you with the answers. And when there is a need for you to clear some certain issues, you look straight into their eyes to be able to to let them know. And then you communicate, your voice should be clear. There are people, when they speak, they either bring the whole room to a standstill, or when they speak, the tone encourages somebody to also contribute. So briefly, these are the 10 issues we have been able to table, even though there are more, but along the line, the time was running out, so we stopped here, and we hope that our colleagues will be able to fit in some.
Okay, thank you. Thank you, room 2. Now let's move on to room 3. Abdul Raf, Eugene, God's Word, Jonas, Mavis. Yes, Eugene, please go ahead.
Room 3, I tried reaching out to everybody, but nobody responded. I tried now one-on-one, nobody responded. I then called you to the host I reached out to the host to come and help. There was no response. So I just had to sit and wait.
Whoa, sorry. As for the host, I received several requests, so I thought I went to other room, so I thought I came there. Sorry. So you were also there for the 20 minutes, no talking. Wow.
I was just by myself, nothing.
Wow. Room 4. Abid, Shah, Francis, John, Kabasa, Joy.
So does it mean that they don't understand what we are teaching, or they just don't want to be part of the conversation?
I know that is what we need to find out, because I don't know why they went to their room and they decided to be quiet. Why they are not interested in what is happening, or they just came to listen.
Because Anna, you didn't share clear work for them in the various rooms.
I asked whether they understand the work. They said yes before I bring them into the group. But they were supposed to go and discuss and come out with checklists as a mediator. And I believe all of them got on board.
Yeah.
So Abid Shah, your hand is up.
So even those who were individuals, they could still present the checklist as individuals. Then it will go towards your credit if we are going to give you a certificate.
Yeah, maybe they thought they wanted to work in a group, so and the group didn't function. So maybe that's the difficulty. A bit.
Did we have a very good discussion?
Room 4.
Yes, room 4.
Room 4.
Yeah.
We have a very good discussion in the group.
Room 4. We're 4 of us in room 4. All of us were there.
Okay.
Yeah. And the checklist you told us this checklist for opening statements.
Yes.
And so we started. We had, even though we didn't have enough time, but at least most of the things that is needed for an opening statement, we highlighted them. First and foremost, we have to, as a mediator, you welcome the parties, both the claimant and the respondent, and you thank them for choosing mediation to resolve their disputes. So you welcome them into the mediation process, and then you go ahead and introduce yourself as a mediator. You introduce yourself, and after introducing yourself, then you tell them that you are a neutral party. You tell them about your neutrality in the matter, and you're a third party, and you don't know any of them from Adam. So you give them that assurance that you are impartial. After assuring them that, then you now introduce the mediation process to them. Introduce the mediation process to them. Then tell them first what mediation is all about, because some of the parties may not know what mediation is about. So you tell them what mediation is about, and then tell them the characteristics of mediation. Tell them first, talk to them about the confidentiality aspect of the process, that everything that in this case will not go out from where you are having that mediation. As soon as you are done, the file will be disposed of. You're not going to discuss it with any other person. That's the confidentiality. We mentioned it. Mentioned that the mediation is cost effective. It's very cheap, very cost effective, and saves time. So instead of they've taken the right decision to come to mediation, because in less than a month or so, their matter will be resolved. And then you tell them about the consent, that mediation is also consensual. Both parties have to give their consent to the mediation, and that when they came for this mediation, nobody coerced them. So it's whatever they agree, and let the party know that they own the process. They are the one that will take the decision. That's one of the things. You have to let the parties know, and also to let them know that it is an interest-based process. It is not a right-based. It's interest-based. It's what they stand to gain at the end of the day. That is what all mediation is about. Then you tell them how the process will go, that as each party, when it's time for them to give their side of the story, each party, after giving you now go into the rules. You tell them the ground rules. When one person is giving his own side of the story or is the concerns he has, and the other party listens and does not interject or interrupt, you let them know all that. Then when it's their own turn, then they will give their own side of the story. You let them know all that. No interruption with phone. You have to make any phone call. You have to get permission from the mediator, and you tell them that, and that in their statements or in their own side of it, they have to make it very brief. You give them time. You tell them how at the same time for each party. Give them time, and that there will come a time where the mediator will have caucus with the parties, private caucus, where at that time, then they will now have the time to explain maybe some underlying issues in respect of the matter, and you state that to them. And then at the end of the caucus, then the parties tell them that whatever they decide will be reduced into terms of settlement. Will be written down, the decisions they agreed, be written down terms of settlement, and when they sign it, then that terms of settlement will now be taken to an area judge for that matter to be, for the terms of settlement to be entered as consent judgment of the court. And that once they sign, it is binding. Let them know that it is binding on them once they sign that terms of settlement. So, and also let them know the beauty of mediation. Let them know that it is not obligatory. It's not a must that they must settle. But we encourage them. It's always good to settle, and that since the mediation process is all about making peace between them, so that they will continue in their relationship. We encourage them that you as the mediator, you are not the one who has authority to take decision for them. No, you let them know that. That's also one of the checklists. Let them know that you are not the one who will take a decision for them. They are the one that will take your own part. You are just to facilitate discussion, facilitate communication between them to enable them make that decision for themselves. So these are some of the things that we put on the checklist, and also advise the parties that everything depends on them. Both parties advise them that they should cooperate with the process, do things orderly, so that everything will end well. If it ends well and they settle, good. If they don't settle, it's their choice. So those are the things that we discussed.
May I summarize it? What the madam he said?
Yeah. You
Yes, go ahead. If you want to add anything, go ahead.
I will summarize it. I already explained each and everything beautifully, but I will summarize it. First, we prepare ourselves for mediation. After the issue, we go ahead with the opening statement. The mediator introduce himself. After that, we understand the parties, the statement of the parties. Then we try to find a common ground, like we try to uncover things, and then we search for the possibilities of the amicable settlement, and then we explain to each and every party the obviously madam I already explained that a separate meeting, and then we explain each and every party the what they're going to forego, and then the closing, we review the purpose and the process of the whole of the mediation. Thank you.
Okay, thank you. Okay, so thank you all for what you have done, especially group 2 and group 4. Well done. So this is a summary of what we have for you. So this is it. Checklist for mediators. So as a mediator welcomes the parties, as you rightly pointed out. So this one will be like a guide to you. So you know that at this point, let me welcome the parties. At this point, let me introduce myself. At this point, educate them about mediation, your role, experience, the center, and add your experiences to it. Then the ground rules, which is spelled out on the consent to mediate. You talk about the ground rules, you sign the consent form, and add any auxiliary issues such as washroom, even if there are water and other things we talk about. Then transition, their readiness to continue with the process, know if the time is right for them to be before beginning. 8 party statements. So first speaker, the claimant, and the second speaker. Summarize what was said and create an agenda. Discuss the agenda. Generate options from the discussion. Look for possible areas of agreement. Search for solution to areas where both parties disagree. Draft your possible solution or outcome. Read it back to the parties for confirmation for necessary corrections. Finalization of the terms of settlement and signature. Then closure, give each party a signed copy of the agreement if it is a physical mediation, and photocopy or print out the signed copy with what both parties agree at terms of settlement just after the mediation session, and hand it over to the part before they leave the premises. So this is the summary of what we expected from you, and I hope this one has put all the things that you discussed into proper perspective for you. All right. So on that note, this is where we'll end for today. If there are no other questions, this is where we'll end for today. And then tomorrow we shall continue with other things. And tomorrow we are going to do proper role play. This one was just to tease out whether you are understanding what we are discussing. And tomorrow we'll do a proper role play. We take it from there. So your assignment is that we are giving the assignment here. Those who are not here, we are not going to post it on the platform. So prepare. Each of you should prepare an opening statement. So prepare an opening statement.
Mobile.
So prepare an opening statement. When we come in the morning, everyone will be asked to post it in the chat. So assignment, prepare an opening statement. It's for those who are here. No one should share it on the platform. Only those who have stayed for us to close. So assignment, prepare an opening statement. This is the assignment, prepare an opening statement. Those who cannot hear, we are saying the assignment, prepare an opening statement. It's in the chat, so check the chat. Prepare an opening statement. Everyone will give their own opening statement tomorrow. So tomorrow you'll be asked to deliver your opening statement. Everyone will talk. Deliver your opening statement. If you cannot talk, you put it in the chat. We'll read it and make the necessary corrections. Then we build on that and we can do role plays. At the end of by Friday, you should be able to do mediation at ease. On that note, let me say a big thank you to all of you for making time to join today, and do enjoy the rest of your evening. We see you tomorrow. It's bye-bye from here.
Thank you.
Okay.
Bye.
Thank you. Thank you.
Thanks so much. Have a
Thank
good
you.
night.
Bye bye.
Thank you, sir.